Good. Okay, so we are over here and we are going to get started with our day 7 in regards to the Christopher Wolfenbarger case. I am going to go ahead and take us right into the courtroom. I will keep you updated on anything that's going on in the trial as we go along. Musical chairs, musical chairs. Right, here we go, guys. Let's see what's going on.
Has the state had an opportunity to make contact if they so chose?
We have not, and we don't need to.
Okay. Is that witness up?
Yes, Your Honor.
Is that witness in custody?
Yes, Your Honor.
Okay. My general understanding is that the sheriff's department prefers to have witnesses that are in custody to bring them in and have them placed on the stand rather than walk them through the courtroom. So if we could go ahead and do that and get the witness. Do we have any other matters while we're taking care of that we need to take up before we get the witness on the stand? Anything from the state?
Nothing from the state.
Anything from the defense?
Nothing from the defense.
Okay. Yes, sir. So just to be clear, Mr. McDermott, I'm still going to ask you to call your next witness, and then I'll just acknowledge that that witness is already on the stand, and then we'll swear them in as normal.
Do you want me to ask on the record permission to treat her as an adverse witness, or do you want me to make an attempt to get her to answer directly first?
I think she's your witness, so you should make an effort to see how cooperative she's going to be, and only if she's not cooperative would you then be justified in asking to treat her as such. Good morning. Ma'am, if you'll come over here to the witness stand. And she might need some assistance getting up onto the witness stand and situated in the chair. You could. Thank you very much. Okay. So we have our witness, and so I think we're ready for the jury, Deputy. Mr. McDermott, the defense may call its next witness.
The defense calls Wendy Waddell.
Okay. Ladies and gentlemen, as you can see, Ms. Waddell is already on the witness stand. Ms. Waddell, if you can, please raise your right hand to the best of your ability. The deputy will swear you in.
You swear affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth.
I do.
These statements will be full name for the court.
Wendy, W-E-N-D-Y.
And if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Waddell, W-A-D-D-E-L-L.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Waddell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenbarger?
I did.
And do you know the Patton family,
I do.
Carl and Norma? And how did you know them?
My parents grew up with them
And did you live next door to them at one point?
as a child.
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
Why did it smell?
Well, people just have a smell.
What was the smell like?
Like a person that
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling
Are
me?
you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about facts. You remember speaking with me on the phone a couple of weeks ago?
Yeah.
And you remember telling me that the smell pervaded the house and
I
the
did.
car
I got on the car.
and
Got
it
on the
stuck
house.
on everyone in the house,
It did.
including Melissa. Did you remember telling me that people bullied her for it,
They did.
picked on her? Do you remember telling me that Melissa had some kind of, it's not a leading question, Your Honor, unless it suggests an answer.
I'm going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa had some sort of skin condition that caused her to have marks on,
Tiger.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I'd look back at it, I'd say autistic.
I'm sorry.
I said, if I had to look back, I would say autistic. She
Okay,
would be autistic.
but you're not a doctor, right?
I'm not.
So you can't diagnose her with autism.
No,
But what made you arrive at the conclusion that she may have been autistic?
just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's
she quiet?
sure.
Was she shy?
Yes,
Was she reserved?
she was.
Did she sometimes react?
She
in-
whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Of a baby.
infantile for her age?
Yeah.
You described to me a period of time in which she would visit her. Do you remember describing a time to me when she would visit her almost every day,
Every weekend. Yeah.
and that you would be locked in the room with her?
Yeah. Growing up.
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door, so that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Objection needed, Your Honor. He's giving the answers.
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer. I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it was started at about age 7,
I'm sure it started early.
went
yeah.
up to about 12?
Yeah.
Okay. You said her sister was locked too,
He's right there.
and she was locked up too?
Mm-hmm.
And
I'm sorry, was that a yes?
Yeah, my mom used to sneak over there and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And,
Is that a yes? You're
Yes, it
nodding.
is Terry Archer.
Thank you.
and what was your father's name?
Bobby.
Bobby. And you said that your parents were wealthy
They are.
and that they paid to be involved in several activities with you.
They did.
What kind of activities?
GYOP. Georgia Youth on Parade. Girl Scouts.
You remember telling me that anything you did, Melissa
She did.
had to do,
That's right.
and that your mother paid for it. You remember telling me that looking back on the way she was treated, being locked in her room and being deprived. Well, let me back up. When you and Melissa were locked in the room, were you allowed to come out during the day? Were you allowed to get drinks of water?
Hang on. Yeah, you're shaking your head. Is that a no?
No, we weren't allowed to come out.
And were you allowed to get a drink of water?
Yeah, we can get, what was they were thirsty?
Okay. You remember telling me that looking back, you would consider that she had been abused and neglected.
Yes.
Today, if someone were treating their child like that, would you call defects?
Relevant, Your Honor. Objection.
Probably.
Hang on one second. Sustained. Go ahead.
Now, did you move away from Melissa's house at some point?
They moved away.
They moved away? Okay. And about what age were you at that point?
I don't know. I quit hanging out with them when I was 13.
Okay. And you told me a couple of events that happened with her before you quit hanging out with her.
She lost her virginity.
And how did that happen?
Objection. Relevance.
Sustained.
Okay. May I approach, Your Honor?
Sure. Sustained. Move on, please.
Do you remember telling me that I caught myself? Was there a time that Melissa did drugs with you?
No.
Okay.
I was doing drugs.
Okay. And because you started to do drugs,
I
you
quit hanging
decided
out with her.
not to hang out with Melissa. You need to let me finish my question. I know it's kind of slow and tedious, but that's just for the record. You got to let me finish my question and then you answer. Okay. All right. Do you remember something Do you remember at some point Melissa started running away from home?
After I quit hanging out with her.
And do you remember that there was something that led up to her running away from home?
Her sister had a still baby.
Do you remember after Melissa was gone that she did not keep in contact with her mother?
I don't remember that.
Do you remember telling me that you don't remember her calling her mother? In fact,
Don't say that.
okay.
How I know that?
And had you ever met Christopher Wolfenbarger?
Never.
No further questions, John?
Thank you. Ms. Hilton, questions for this witness?
Oh, actually, do you remember telling me that when you knew Melissa and hung out with her, that her mother would not let her have anything like makeup?
Mm-hmm.
Is that a yes?
Yes.
Thank you.
And what did she do instead?
Use colored pencils.
Do you remember whether she was allowed to have feminine products?
Yeah.
You remember telling me on the phone that she had to use socks?
No.
If I showed you a transcript of our discussion, would that jog your memory?
Why would I say that?
Can I show you a transcript of our interview?
Sure. I never said that.
Would you like me to play the audio?
Sure. I must have been high.
Permission to share, permission to share, Your Honor?
Granted, just make sure that what you're going to share is only the portion that is relevant to the question you just asked.
I can imagine she was traumatized.
She was traumatized. She was. And let me tell you, like, makeup, when she would put makeup on, she would have to use color pencils because her mama did not give her those things.
Oh.
You know, like she, you know, would have to use, I hate to say it, but like socks for pads and shit like that. You know, because her mama neglected.
I guess I did say that. I was high.
No further questions, Your Honor.
Thank you. Ms. Hilton?
Good morning, Ms. Martin. How are you?
Withdrawing.
Withdrawing. Okay, but you answered his questions. Have you and I ever met? Is that a no for the record?
No.
And have we ever talked on the phone?
No.
And you spoke with Mr. McDermott a few weeks ago over the phone? Is that a yes?
Mistake. I thought it was you.
Oh, no problem.
But go ahead.
But you talked to him about a lot of different things. Is that fair to say?
Yes,
Okay. And so you were her next door neighbor, correct? Melissa's next door neighbor.
as a child.
And as a child, that from between the ages of 7 and 13,
No,
what were the ages?
ages of 2 to 7.
2 to 7. Okay. And your parents are friends or were friends with Melissa.
Our friends.
And you said you spend time at her home every weekend, correct?
Did.
And you just testified that there was an odor in the home that you didn't like. Is that fair?
So yes,
Yes,
thank you.
But every weekend you would still go to the house.
yes, I love them.
And I think you testified earlier that your mom would have to take Tina out the window,
She would.
but your mom still let you go over there every weekend.
She did.
Now, you said that Melissa was able to do Girl Scouts with you. I think you told defense counsel over the phone cheerleading, and then you just said like a girl youth group. Is that the third thing you just said?
Something like that.
And it's safe to say that her mother will let her go with you
For
to
sure.
do these events. Although your family paid for it, her mom let her participate in those activities.
She would.
And that kept you all busy. Is that fair to say?
It did.
That's a lot of activities, right? Now, at some point, is it fair to say that your mom moved to Covington and you moved to Covington?
I did.
About how old were you when you moved to Covington?
13.
And Melissa would still visit you while you were in Covington.
She did.
And so her mother would let her leave from Stockbridge, is that a yes?
McDonough.
From McDonough and come see you in Covington.
She would.
How far is that?
30 minutes.
So it's safe to say Melissa would have to come out of the room in order to come see you. Is that fair?
No, she didn't lock her in the room like at that age.
Okay. Now, when you all were younger, did you tell defense counsel that you all never knew what Carl Patton had done?
Never.
You did not know.
We didn't. Not until they came and got him.
And when you said when they came and got him, are you talking about you found out in 2003?
I'm talking not until the police came and got him.
Okay. Now, is it fair to say that the last time you saw Melissa was in 1997?
Last time I saw Melissa would be about 1998, 97.
97, 98. And I'm sorry, did your family have like an event every year and the
They did.
Pattons would attend?
Yes.
What type of event was that?
Holidays.
And you talked about Melissa's kind of demeanor. In your opinion of knowing Melissa, would she ever just leave her children?
No.
Would she ever just stop talking to her children?
No. Not that I'm aware of.
Now, when you spoke to Mr. McDermott, you described Melissa as not bright at times?
No.
No, you didn't, or no, she
Yes.
wasn't? I'm sorry.
Yes, she's not right.
Okay. That she was easy to control?
She was.
You said that she was weak?
She was.
You said that she was submissive?
She was.
You described her as a type that would not fight,
She don't.
that she was very naive,
She was.
not a smart thinker.
Mm-mm.
Mm-mm.
Not a smart thinker.
You said that she's dependent on whoever she is with,
That's right.
that she would not be the leader in a relationship.
She would be.
Matter of fact, in your friendship, she kind of follows you.
She did.
And you said kind of after you left, Melissa had no friends.
Right.
Now, I know you just told defense counsel that you never saw Mr. Wolfenbarger, but you had the occasion to speak to him one time on the phone.
Well, I guess, very short. He would let me talk to Melissa.
Tell the jury about that.
He just wouldn't let me talk to her.
When was it?
In 97, 98.
Do you recall telling Mr. McDermott that was around Thanksgiving of 1998?
Something like that.
And that you actually called to speak to Melissa on the phone?
I did.
And Chris answered the phone
He did.
and he wouldn't let you speak to
He
her.
wouldn't.
And he was controlling her ability to talk to you.
He was.
And it's fair to say that at that call, he did not want Melissa to talk to one of her childhood friends.
Objection.
Sustained.
It's true.
When there's an objection and I sustain it, you have to not answer the question,
Sorry.
okay? Thank you.
And was that the only time that you talked to Chris in Thanksgiving of 1998?
Yes.
Court's indulgent. Sure. No further
Hey,
questions.
thank you. Mr. McDermott, any additional questions?
Yes, ma'am. You just told the state council that when you talked to me on the phone, you thought it was them.
I did.
Is that correct? And didn't I tell you on the phone, I'm Christopher's attorney?
No.
Uh,
He said defense.
Okay. Permission to play some audio, Your Honor?
She said you said defense.
Okay, so I did tell you,
Just making sure you heard her answer.
I did tell you I was the defense attorney.
You did.
Correct. And then I told you I'm Christopher's
You
attorney.
did tell me that
Okay, thank you.
afterwards, yes.
At the very beginning of the conversation.
Look, I get high every day. I do drugs. So I'm just trying to tell you, I don't know, what I say. And I hate to burst your little bubble. I'm just telling you, like, I do heroin every day. And I'm going through withdrawals. And that's the whole point I didn't want to come here. So I don't know what this would be.
Were you on heroin when you talked to
I
me on the
was.
phone? You're on heroin right now?
Only because I'm locked up. Sweating to death.
Just to reiterate, you quit hanging out with Melissa around age 13, correct?
I did.
So you had really not much interaction with her after that.
I didn't.
So you don't know what she was thinking or doing after that age.
No.
No further questions, Your Honor.
Thank you. Ms. Hilton, anything else?
In that Thanksgiving 98 call that we just talked about, do you recall telling defense counsel that the Pattons were at your family's house for a family function? Is that a yes?
Yes.
And that it was during that family function you asked about
Her.
Melissa, and you said, "Give me a number so I can call her."
I did.
No further questions.
Mr. McDermott?
No further questions, Your Honor.
Okay. Ladies and gentlemen, just for some logistics, I'm going to have to ask you to step out for just a moment and I'll have you right back as quick as I can. Jury's clear. You may be seated. Deputies, if you'll assist Ms. Waddell, she's excused as a witness.
Yes, Your Honor.
Thank you, Ms. Waddell. I was just going to say, I trust that her release will be processed as quickly as possible. Mr. So I understand what's going to happen when I call the jury back in. Does the defense have any other witnesses or is the defense planning to rest?
Defense rest, Your Honor.
Okay, well, I'm going to need you to do it formally in front of the jury. I'm just asking in advance. Does the state still have planned rebuttal?
Yes, we had two witnesses for rebuttal.
Okay, and do you have them ready to go outside the door?
One is right outside the door, and the other is our DA investigator.
Okay,
Sitting right here.
okay. Okay, so we're ready for the jury to come back in then, and we'll have the DA rest and, or excuse me, the state will rest and the DA can take up its rebuttal. Is that a yes, Ms. Hilton?
Yes.
Okay, is that a yes, Mr. McDermott?
I'm sorry, Your Honor, question?
Okay.
Question again, please?
Are you ready for us to come in and proceed in the manner I indicated, which is that y'all are going to rest once the jury comes back in and the state's going to take up its rebuttal?
Yes, Your Honor.
Thank you. Well, please be seated. Mr. McDermott, the defense may call its next witness.
Your Honor, the defense rests.
Thank you. Ms. Hilton, any rebuttal from the state?
Yes, Your Honor, briefly. The state will call Detective A.B. Calhoun.
Okay. If you'll coming up to the witness stand, and before you, once you get there, if you'll turn and face the deputy and raise your right hand, he'll swear you in.
You swear upon this testimony that you're about to give, truth, the whole truth, and nothing but the truth, says you got
Just be careful of that ledge and then scoot up to the microphone and state and spell your name for the record, please, sir.
My name is Alton, middle initial B, Calhoun, A-L-T-O-N, again, B-C-A-L-H-O-U-N.
And good morning, Detective Calhoun. How are you?
I'm doing fine.
I want to direct your attention specifically to April 7th of 2003. Did you have the occasion on that day to speak with a Kimberly Cameron?
Yes, I did.
And how did you make contact with Ms. Cameron?
I made contact with her, phone contact with her.
And who, at the time, did you know who she was?
I knew that this was a very close friend, a very close friend of Melissa Wolfenbarger, and also Chris Wolfenbarger's sister.
And did you speak with her on that day over the telephone?
Yes, ma'am, I did.
And what, if any, let me ask you specifically, was she able to tell you about her relationship with Melissa?
Yes, ma'am.
And was she able to tell you about Melissa's feelings towards her brother?
She shared that, yes, she was.
What would she tell you?
She shared that they had problems as a couple, like everyone else. Sometimes they had problems.
Did Melissa ever tell you did Kimberly ever tell you if Melissa was planning on leaving her brother?
Yes, ma'am, she did.
What did she say?
She said that we were speaking, and she indicated that a conversation that she had with Melissa. Melissa expressed her love for her brother, but while she loved her brother, that she was planning on leaving him.
And did Kimberly ever indicate that Melissa wrote her a letter?
Yes, ma'am, she did.
Does she still have the letter?
I don't know. I asked her about when we were doing the interview details if this was based on something from the letter, so I don't know where the letter may be.
And after speaking with her on the telephone, did you have the occasion to try to meet with her in person?
Yes, and I'll say that the telephone conversation was, the purpose of that was to set up a time that we could come meet, and I can interview her more in detail.
And did you eventually meet with her?
Yes, ma'am, I did.
And when did you meet with her?
Well, that was April 23rd.
And when you met with her, was there anyone else present with her?
Yes, ma'am, there was.
Who was present?
Her mother, Kathy Wolfenbarger.
And during that meeting, were you able to speak with Kimberly by herself?
No, ma'am.
Why not?
When I got there, of course, I met Kimberly and I saw that Mrs. Wolfenbarger was there and learned who she was. And I told her that I would like to speak with Miss Kathy as well, but it was my intention to interview her, Kim, and then speak with her mother. And that I would like it. It'd be nice if her mother was to be able to leave, but Kathy made it very clear, I should say, that she was not going to leave. She was going to stay there with her daughter at the interview. So at that point, I had no other choice but to interview them together.
And where did you go to conduct the interview?
I went to Kim's home.
So this was at Kim's house?
This was at her house, yes, ma'am.
All right. I have no further questions.
Mr. McDermott?
Mr. Calhoun, you interviewed a lot of people during this investigation around that time, correct?
Yes, sir.
You interviewed Christopher, didn't you?
Yes, sir, I
And
did.
do you remember making an audio
Yes,
version of that interview?
yes,
Do you remember interviewing Don Perone,
yes,
the neighbor down the street?
yes.
Do you remember Don telling you he drives a hearse?
Objection, hearsay.
Sustained.
You made an audio recording of that interview, correct?
Yes,
Okay. And you interviewed several other people. You made audio interviews of them.
yes.
And we have something like 6 audio files that you created.
I'm not sure the number.
Does that sound roughly correct?
That sounds like that.
Okay. And for this discussion with Ms. Cameron, did you audio record that?
Which the initial phone interview,
The one you just testified about right here?
I believe I did. I'm not sure. All the interviews were there. If I recorded an interview, it was in the file, but there were some times where I just wrote things down from my notes.
So if there's no audio in the file, then you didn't do one?
There was no recorded interview. I just went on the notes from that interview. Yes, sir.
So what you testifying here today from the notes you wrote?
Excuse me?
Are you testifying here today from the notes you took on that interview?
Yes. And when I say notes, the notes that I did, the way it happened is, as investigators do, we have notes, a notepad, and you'll just write notes throughout, over the course of the investigation. I then at some time take those notes and transcribe those to the report.
Okay. Do you mind if I see your report?
Yes. Those would be the 2 pages from that time frame.
So those are not recording anyone's exact words, correct?
No, I just gave a brief synopsis. If you read these notes, you'll see there's just a synopsis of what they said to me.
Okay. And we have no way to check to verify if that's what she actually said.
What's that? Who's that? I'm not sure who you're
So
talking
you
about.
interviewed Kimberly, correct?
Yes,
And all we have from that interview is your written notes on it.
yes.
So we have no way to verify that that's what she actually said to you.
I guess that would be correct.
Okay. No further questions.
Ms. Hilton?
Did you have any reason to make up what your conversation was with Miss Kimberly Campbell?
No, ma'am, this was something that I had no reason to make anything up.
Thank you. No further questions.
Mr. McDermott?
No further questions.
Okay, thank you, sir. You may step down.
Thank you, ma'am.
Ms. Hilton, state may call its next witness.
Yes, Your Honor, the state calls Andre Curitan to the stand.
Okay. Well,
Thank you, sir.
okay, so they
Do me a
just
favor,
come
come to
people
the
back
witness
and
stand.
forth.
When you reach the witness stand before you have a seat, if you'll turn and face the deputy and raise your right hand, he'll swear you in. Yes?
I don't know, this last person that we've seen that's currently about to take the stand, I don't think we've seen this person. I don't recall seeing her, but I could be mistaken.
Swear in the witness?
You swear or affirm the testimony that you're about to give, the truth, the whole truth, and nothing but the truth, so help you God. You may have a seat. Please state and spell your full name for the court, please.
First name is Andre, Andre. Last name is Curitan, Cureton.
And where do you work?
Fulton County District Attorney's Office.
And what do you do for the Fulton County District Attorney's Office?
I'm a senior investigator.
And just describe briefly some of your job duties as a senior investigator.
We mostly, we're assigned to attorneys. Anything they need, any evidence to be picked up, we subpoena witnesses and sit with our attorneys as they interview the victims or witnesses.
And are you also required to sit in the trial of those attorneys as a trial may proceed?
Yes,
And have you been sitting in this courtroom for the duration of this trial as it's been proceeding?
yes,
Now, as a part of your responsibility, you said that you have to meet with witnesses with the attorneys.
yes,
Do you recall ever meeting with a Norma Patton?
yes,
Okay. And when you met with Norma Patton, do you recall her ever providing to the state letters and cards?
yes.
What did anything happen with those letters and cards that she provided?
She provided to them. No, we made copies of them. When legal assistants made copies of them, so we could have.
And so did she bring originals and the legal assistant would always make copies of those originals?
Yes,
And I'm gonna show you what's been admitted as 67, 68, 69, 70, and 71. Are these some of the letters and cards that Ms. Patton provided that you made copies?
yes. These are some of the ones she brought in.
And then we made copies of?
Yes.
Thank you. No further questions.
Mr. McDermott?
I have no questions for this witness, Your Honor.
Okay, thank you, sir. You may step down.
Thank you.
Ms. Hilton, state may call its next witness.
Your Honor, the state has no further witnesses. The state rests.
Mr. McDermott?
No further witnesses, Your Honor.
Okay. Okay, so that means the evidence in this case is closed. Ladies and gentlemen, there are a few things that we have to take up to get ready for closing arguments and the final jury instruction before you begin your deliberations. And so it's about 10:20. I'm going to excuse you. I'm guessing conservatively about 20 minutes. I'm hopeful that we'll be back in here around 11 just to give you a target for what to aim for. But for now, you are excused. We'll have you back as quick as possible. Thank you.
All right, for the jury.
Wow.
You may be seated.
Yeah. Let's see if they're going to talk about something.
Yes.
So we need to revisit some matters that we were dealing with yesterday in order to finalize jury charges. Are there any matters other than those? Are there any matters the parties want to bring to the court's attention that we need to address?
I don't think we have
No?
nothing from the defense.
Okay. So so I have sort of a bullet point list of things that I was supposed to do homework on last night. I have, and so let me address a couple of things. Number one, I have looked at the request from the defense to provide a charge on immunity of a witness. I think that the better course here is to not give it. It's not directly implicated by the facts of this case, and the defense doesn't need it to make the argument that it wants to make. And so I'm not going to give the immunity charge 131.80. Mr. McDermott, you asked me to adjust the circumstantial evidence charge to change the word theory to the word hypothesis. I'm not going to do that. The pattern is the pattern, and I believe the pattern is there because theory is a more accessible plain language word than hypothesis is, and that's why it's been changed. And so we're going to stick with the pattern.
Excuse me, sorry.
I'm not going to give the prior difficulties charge. And that, as I consider it legally, I think there is a conflict I cannot find case law. And if you can point me to some, I would appreciate it. But I cannot find case law that distinguishes between the fact that prior difficulties, there's tons of case law that talks about the fact that prior difficulties are likely for intrinsic evidence, right? There's secondary sources and there's cases that say that prior difficulties is likely intrinsic, et cetera. But what I can't find is case law that reconciles this tension between the fact that if the court has ruled, which it has here, this evidence of the dealings between Mr. Wolfenbarger and the victim is intrinsic to the case, then I think that the evidentiary standard is very clear that that evidence can be considered for any purpose. And prior difficulties evidence would be the charge that's been requested by the defense is what would apply to evidence that wasn't otherwise intrinsic, but that was allowed as a prior difficulty. And because I've allowed it as right, wrong, or otherwise, because I've allowed it as intrinsic evidence, the jury can consider it for any purpose. And I think that instructing them on prior difficulty would confuse the jury about what the standard is that they are to apply. And so I'm not going to give it. The last issue is really two issues, which is I took under advisement the motion for directed verdict of acquittal on count 2 for felony murder, and obviously the associated jury charge that goes with that. If I grant the DV, then I wouldn't give those charges. I spent a good bit of time with this last night, and while I agree again with the state that there is evidence here from which either facts or reasonable inferences from which a reasonable finder of fact could determine that a homicide occurred and or that Mr. Wolfenbarger may have committed it, I do not believe that there are facts from which a reasonable fact finder could even make a reasonable inference that a weapon was used or what kind of weapon was used. And because of that, I don't believe that the state can, I don't believe that there are facts from which the state could present the count 2 felony murder, which requires that showing of aggravated assault. And so I'm going to grant the defense's motion for directed verdict on count 2 of the indictment for felony murder, which means that I would not give those charges. It means that the jury, I need to amend the verdict form to include the sole count of the indictment for murder. We also need a redacted indictment reflecting only that one count of felony murder. What record would anybody like to make regarding that ruling? Mr. Wilson, you're standing.
I would, Your Honor, and
Yes, sir.
I'd like you to reconsider it in light of, I did look for some case law, and I thought what would be very helpful to everybody is case law where a murder occurred where either the body was never found or there was decomposition. They couldn't determine the exact cause of death based on advanced decomposition. And what I found was Richardson versus State, and the site on that is 278 Georgia 548, and it says that if there is evidence of an act, the jury can, and remember we're dealing with the standards for directed verdict, whether there's a reasonable path for a reasonable jury to follow the state of facts. And Your Honor, I do think that also on Courier versus State, which is the site is 294 GA 392. This was a case where there was, I mean, it's very similar to our case in that the remains of the victim were subject to decomposition, and the medical examiner gave an almost identical cause of death, which is undetermined homicidal violence. And that's what we had from Dr. Terry.
Right.
And that was acceptable. And I believe, and that's actually a felony murder case, Your Honor, predicated on aggravated assault, where there was a non-specific form of aggravated assault. The court said that there had to be some evidence, and I'm going to get there really quick.
Mhm.
Your Honor, and I do believe that the court has evidence, and the jury has evidence. As the court said before, the court was going to consider the prior acts of the defendant to the victim as intrinsic evidence. I think that's critical to the analysis on whether, and this is, like I said, this is a directed verdict standard. It is critical when the court makes that ruling that this jury can infer from the fact that he's done it to her in any indeterminate manner before, he'll do it to her, he could do it to her again. I think that's a completely reasonable assumption. And that's what the case law says. They can consider it for any purpose that they choose, Your Honor. So I think that because it's intrinsic evidence that there has been past domestic violence, you've got that. That's the big thing. You've also got the medical examiner saying undetermined homicidal violence. You've also got Rosa James saying, educating the jury on the cycle of violence and what happens. Your Honor, there is a path, and I understand where the court's coming from. But I think when you allow intrinsic evidence that can be used for any purpose, that's what the question is on a directed verdict. It's not whether or not it has to happen, whether it's possible that it could happen. And I think a jury can take that evidence of the prior assault and say, you know what? Given the escalating type of violence, this is now an aggravated assault. And this is why she died. And that would bring it in directly with the case law. So that's our argument. Your Honor, I think the court should reconsider its motion, or its ruling on the motion. and allow this case to go to the jury, because I think there is evidence, and I know the court was struggling with that extra evidence, but it's there.
Couple of questions. One, I was able to pull up the Courier case. I'm not, the first case you gave me, I don't know if I typed it in wrong or wrote it down wrong. Can you give me that site again?
Sure can. It's 276.
Wait, say it again?
276.
276.
That's what, I think we all wrote down 278, or at least that's what I wrote down. 276 Georgia 548.
Yes, ma'am.
Thank you.
I mean,
I will tell you, one of the reasons that I wanted to make sure I had the right citation for that case is that my brief review of the Courier versus State case is it would be distinguishable because I think in that case there was direct evidence of some sort of scuffle between the alleged perpetrator and the victim prior to the victim then later being found dismembered and in a decomposed state, which is evidence from which a jury could find that aggravated assault of which there was evidence caused the death. I mean, I read that case very briefly to be more about proximate causation than about whether there was evidence of an aggravated assault, because it sounds like there was.
well, and I think when you, like I said, when you allow intrinsic evidence, is there a path? That's the thing. Is there a path for a reasonable jury to conclude that the violence escalated and this defendant committed an aggravated assault? I think it's relatively settled that the manner of aggravated assault is not really the relevant factor. It's is there evidence? And I think Richardson talks at that, and I think Courier does too. But I think with the intrinsic evidence of past violence and the fact that the jury can consider that for any purpose they want to, and given the standards on a directed verdict, could they do it? Absolutely, Your Honor. That's our position. So I'd ask that you reconsider.
Okay. I appreciate that argument. First paragraph of Richardson says that there were bloodstains found on the victim's bedroom ceiling and walls that were evidence of the infliction of severe blunt force trauma. That's, again, factual evidence from which a jury could make a reasonable inference. What we have here is a history, right, between the defendant and the victim, but no direct evidence of a particular interaction between the two of them that could constitute an aggravated assault. And more specifically, there's no evidence from which a jury could infer the presence of an dangerous instrumentality or offensive weapon. And that's really, to me, the deciding reason. I understand the state's theory, but I still don't think that there are facts or reasonable inferences that can be drawn from those facts, from which a jury would be justified in determining that an offensive weapon existed and or that an aggravated assault occurred. There is evidence from which a jury could infer and determine that a homicide occurred. And so that's why I've ruled the way I have. I understand the state's objection. Is there any further record that you would like to make on that point, Mr. Wilson?
I don't believe so, Your Honor.
Okay, thank you.
Your Honor, I'd
further
also
defense?
point out that Richardson's a malice murder case. It's exactly what you're holding in this case. There's sufficient evidence for malice murder.
Okay. Anything from the defense? Okay. So it is 10:40. What I need to do is I'm going to, as I said, edit the verdict form. I'm going to email y'all in just a moment. I'll probably have my staff print a final, or more final, unless y'all tell me there's something else to address, version of the jury charges. Is the state in a position, because y'all have, my understanding is it's easier for y'all to print a version that's whited out of this. I can have my staff get rid of count 2 in both places if you want me to, but since the indictment goes back with the jury, they need a clean version of it, which is that one count. Okay? Okay. It is 10:40. My goal is to be back in here at 11 with everyone's final approval of the verdict form and the jury charge, and then ready to start with closing arguments. Is that good with everybody? Mr. Fawcett?
Yes, sir.
Mr. McDermott?
Yes, Your Honor.
Okay, we're in recess until 11. Okay, Madam Court Reporter, you ready? Yes. Okay, so Mr. Wolfenbarger is back in the room. I have.
Y'all know we got that good old T-O time, right?
Form that is
So we get
only
to see
count
past
one
that
for
part.
murder.
No need to listen
The
to that
state has provided
unnecessary
me and Mr.
stuff,
McDermott has had the opportunity
right?
to
Well, they
review a
wasn't talking.
redacted version of the
Lunch,
indictment
whatever,
that only
break.
charges the one count of murder. I've also provided the lawyers with
Yeah, only
the
fan
jury
said back to
charges that I
Donna.
have
Donna's
redacted,
still eating lunch.
and tailored further to the evidence
Donna
in this
has not
case to
returned
remove
yet.
references to the second count of the indictment and to remove, for example, like I usually have a pattern that says, there's a multi-count indictment, so I've removed that. And wait, I just realized I missed one. I need to remove prior difficulties, which I advised the parties I would not be giving. So if y'all could please make a note, I'm removing it from the version that's going to go to the jury, and I'm removing it from the PowerPoint that will be displayed. But if y'all could please mark that out in your packets. And I believe that now that I have removed the prior difficulties charges, I indicated I would not give it. I believe that the version that I have provided you accurately reflects the rulings that the court has made in terms of what the court intends to give or not. If you've had a chance to look at it, any objections to the charge that the court intends to give from the state?
No, yeah.
Mr. McDermott for Mr. Samuel from the defense?
What we wanted prior difficulties.
Yes, sir.
We wanted 404B.
Yes, sir.
Do you need us to renew our objections after the charge, or is this the only time to preserve?
So what I was expecting, other than preserving the objections you've already made,
Right.
Do you have any additional objections to the charge that the court intends to give?
No.
Okay. And then after I give it, I will give you an opportunity to say that you object to the charge as I gave it.
Right.
Okay. And then the verdict form, which is just the one count. Does anybody have any objection to the verdict form?
No, yeah.
Okay. So what I'm going to do in just a moment then is bring the jury in. And just so you know, I will provide the jury with a copy of one copy of the jury charge, the verdict form, and the redacted indictment. That will go on top of whatever evidence the parties agree is going back with the jury, subject to any continuing witness or other objections the parties may have. I know we have one, just to flag it for everybody's memory, Exhibit 30A is a redacted version of I think, audio recording, and we're in agreement that 30 is in evidence but would not go back. It's 30A that would be played for the jury if they wish to see it. Beyond that, I will rely on the lawyers to tell me if there's any additional evidence that is in evidence but should not go back with the jury. Anything else before I call the jury and then we get started with closings? From the state?
No, Your Honor.
From the defense?
No, Your Honor.
Okay. Do you have a PowerPoint?
I do.
Okay. Are you logged in and ready to go with it?
I am.
Okay. You can go ahead since I'm going to go straight into, well, I take that back. Are you going to open and close, Mr. Fawcett?
No, just the open.
Is the state going to open and close?
Started out.
Right. Okay, so since the state is going to open and close, you can go ahead and have your PowerPoint up and ready to go on the screen. We're ready for the jury.
What time do you plan to take a break?
I've ordered lunch for the jurors at 1:30, and so my plan is to see if we can target being done at 1:30 or shortly before, but if we can't, then we'll keep going unless the jury says they need a break. focus on the closing arguments and the jury charge when I give it to the jury. And so I'll ask that you not go in and out. And if you absolutely have to go out, if you'll please do so as quietly and non-disruptively as possible. Thank you. Please be seated. Ladies and gentlemen, I'm now going to allow the parties, the state specifically, to make its closing argument.
Thank you. So what's being depicted now is one of the first exhibits that we introduced. That is a photograph of Melissa John Wolfenbarger. And that's a photograph that was taken somewhere around 1997, a year before Melissa went missing. In 1998. We know that in 1998, she was 21 years of age. So she's roughly about 20 years old at that point. And even though she hadn't gotten a chance to live a very long life, she was a mother at that point. She was a wife. And when I look at, when I see that photograph, I see a smile, but I also see hope. I see hope when I look at that photograph because of what she must have thought about her children, what she hoped for them, the life that she hoped to live. And I think about the 27 years that has passed and how long that is to wait for justice. But that 27 years, that's a long time to experience life. That's a long time to fall down and get up, and fall down and get up. That's time to experience and have memories with your children. Children that don't have a memory of Melissa. Not Joseph, not Christina. That's an opportunity to have and create memories with your grandchildren. I have 3 grandchildren that you heard Christina testify. She's got 3 boys. It's opportunities. That's what was missing. That's what has been missed. That is what has been taken away from Melissa. The opportunity to have a life, to have those experiences, and she deserved that, even if she didn't want to spend it with this effect. Even if she wanted to leave him, she still deserved to have that opportunity. She was manipulated, she was intimidated, she was abused, and she was coerced to give up her children. I believe that's what the evidence shows. And I can tell you, 27 years later, I would not expect a judge to allow a defendant that battered his wife to be alone with them, to speak to them 6 days after it happened. Roughly 5 or 6 days after they went down to apply for a protective order. 5 to 6 days after the order and had no contract was in place, the judge lets her speak alone with him. And then on that very same day, I want to dismiss. On that very same day, children go back with mom. And we don't know what was said. We don't know what was said there. We don't know what he said to them. We don't even know if the bruises that were on her from his attack on July 21st, 1990, we don't even know if those had fully healed yet. I can assure you the mental and emotional trauma from that act, having to call the police after a period of time in July where we know she had already been abused and experienced abuse. violence and you're thinking about being intimidated and coerced, that's what I want you to think about when we look back at that date, July 29th. I believe the evidence shows that she was intimidated. She was able to be influenced, especially after being beat for a year by this defendant. And I don't believe that she ever intended to give up her children and walk away from her family and her
Your
children.
Honor, I want to object to counsel's repeated use of "I believe," "I can assure you." Counsel is not supposed to interject personal opinion.
Understood. Mr. Fawcett has offered to rephrase. Go ahead.
Now, the indictment you'll get will have one count of murder, for the malice murder, the intent to kill, the intention to kill. Kill Melissa Walker. And this is why we're here, from what was found on April 29th, 1999, and June 3rd, 1999. Skull of Melissa Wolfenbarger, right on his job. Within that same vicinity, and it would have in a minute from the residence where Christopher Wolfenbarger and Melissa Wolfenbarger lived. And your judge is going to instruct you that you are duty bound to follow the law. And in your consideration of the law, you should consider certain things and certain things you should not consider, such as sympathy for either the victim in this case or the defendant, disagreement with the law, conjecture, dislike of the system, television, public opinion, penalty or punishment. The only thing that you are to decide when you're considering the evidence is whether or not the state has met its burden beyond a reasonable doubt and prove a guilt for innocence of the guilt of this defendant. You should consider the elements of the crime, the law which the judge will give you. The oath that you've taken as jurors, facts, the case as presented in the form of testimony, video exhibits such as the video of the defendant hiding, audio exhibits such as the audio of the defendant stating that you never looked for her, acknowledging that he took assault, also acknowledging that she was dating someone and seeing someone and staying with someone named Mike. You also consider the credibility of the witnesses. What was it like when they were testifying? How did they answer the questions? You are entitled, you're the determinant of the credibility of not just the state's witnesses, but also the witnesses that the defendant called. You all consider what the defense is. Now, the defendant doesn't have to present any defense. Walk into court Tuesday, Wednesday, say, hey, make improvement. But that's not what happened in this case. The defense in this case is Carl Patton. Listen to the theory and opening statement. The defense in this case is Carl Patton killed Melissa Wolfenbarger. Other than the fact that evidence came in that Carl Patton committed murders, what other piece of evidence or fact, anything that you heard during the course of this week, what points to that? What other fact would allow you to create that evidence? Other than the fact that he killed someone, the evidence came in, Melissa didn't even know about it. The only thing that's come in about the relationship between the Pattons and their children is that they appear to love each other. It's not so unbelievable. Based off of the letters that Melissa wrote, cards that she wrote, times that she wanted to take her father, Carl, and her mother, Norma, out to lunch. Those are going to be back in the room if you observe and look at why you deliberate. This case is just simply not about Carl Patton as much as they want it to be. This case is about domestic violence. This case is about intimidation. This case is about loss of control. The loss of control that this defendant had over the custody of his children and over Melissa. No matter how much they want this case to be about Carl Patton, this case has nothing to do with Carl Patton other than the fact that he asked law enforcement to find his daughter? Why does Norma go to the residence of Kathy Wolfenbarger looking for Melissa, raising attention to that issue, getting their responsive report? Now, a lot of facts have come to evidence in this case. I would ask you to put back weight on more the facts that have been corroborated, like that. You heard that from Norma, and you don't have to just take Norma's word for it because you heard that from Christina. She does not have a lot of memory from her childhood. She doesn't have a memory of her mother, but she remembers that day. Because that stood out at her. Where's my daughter? I could just imagine how that was. It wasn't a calm statement. It was screaming, where's my daughter? Norma probably showed up to that residence of Kathy in a panic. Where's my daughter? That's something that Christina would remember. And that's why you should believe that happened. And that's why that theory is just plain ridiculous. He killed Melissa Wolfenbarger. Most importantly, in common sense, it's the main thing that we're asking you to use in the side of this case. What does the evidence tell you? What are the facts tell you? What has been presented? Judge is also going to charge you on what reasonable doubt is and what it is. Judge is going to charge you that the state is not required to prove the doubt of the guilt of the defendant beyond all doubt for mathematical certainty. Reasonable doubt is a doubt of a fair-minded, impartial juror honestly seeking the truth. Is a doubt based on common sense and reason. It is not mean a vague or arbitrary doubt, like Carl Patton. A arbitrary, not supported by the facts, thrown out, hoping to stick on the wall. Evidence may be direct or circumstantial, or both. Consider the evidence, you may use your reasoning and common sense to make deductions and reach conclusions. May be direct or circumstantial. Direct evidence is that which may be seen or heard. Otherwise, direct consents. So when Christina says, I saw Norma show up to the residence in a panic looking for her daughter, that's direct evidence of her observations. And from that recollection, the testimony of Norma, you can infer that Norma was sincere when she was looking for her daughter. The types of inferences that you can infer from the facts that have been presented. And then we have the circumstantial evidence. This is exactly what I was referring to. We got direct evidence of tool marks on bones that were recovered and identified as the remains of Melissa Wolfenbarger. Tool marks are direct evidence. Those are observations. You'll have those that you will be able to review and look at while you deliberate. We also have direct evidence that the defendant was in possession of assault. Two separate facts. Now you wouldn't, and we wouldn't walk into court on Wednesday and ask you to convict because there are tool marks on the bones and remains of Melissa Wolfenbarger. And we wouldn't ask you to walk in here on Wednesday when we started presenting evidence to convict this defendant of murder because he was in possession of assault. And you draw logical, common sense conclusions from that. That's just one piece of the evidence that has been presented, which you were able to do that. We had assault around the same time that the wife was missing, the wife's remains were located. Medical examiner says there's assault that we presented as Exhibit 66 is consistent with the type of marks that could be made by that instrument. And in his own statement that he was in possession of it around that time, and in the statement of the rocks, although they were reluctant to say so, that they never got that assault back. We would not ask you to convict solely based on that fact alone, but that is a fact that you can consider, and those are inferences that you can draw. Reasonable, common sense inferences. So this is what I saw when I woke up this morning. I probably see this a lot more than most people, but when I woke up, this is what I saw. And I had time, so I stopped by to get some gas. And by the time I finished, I got back and I crunk up the car, and I'm back on forward. So I never saw anything going to my vehicle, but during that period, I smelled what appeared to be gas because I cut grass. I smelled gas. There's less money in my account. The numbers on the dial are different. I hear a clicking sound. And so, even though I never saw any gas on my vehicle, there are logical deductions and conclusions that I would draw from all those facts and circumstances. Nobody's going to be able to come and tell me that Santa Claus put gas in the vehicle. So when we ask you to use your common sense and look at the facts, the evidence is what it says it is. The facts are what they are. In the count of murder, you'll get the indictment. You'll see that it's charged that the defendant with malice aforethought cause and cause the death of Melissa Wolfenbarger by inflicting homicidal violence. Now, as it's charged, that term homicidal violence, based on the manner in which the remains were recovered, it is impossible for the medical examiners to determine if she was shot, if she was strangled, if she was stabbed, any number of ways that you could commit a murder could have been committed to Melissa Wolfenbarger. But you can't tell if someone has been strangled if the neck is missing. You can't tell if they're stabbed or shot in the torso if there's no torso. And what we're able to determine based on the testimony of the medical examiner is that the facts and circumstances what she observed is how the remains were located, the history and evidence of domestic violence in that relationship, the fact that there's evidence that someone removed her limbs with salt. All of those facts, and the fact that her testified in her medical expertise, she did not believe that Melissa Wolfenbarger died of natural causes. All those are facts that point to homicidal violence. In her opinion, was that it was more likely that Melissa Wolfenbarger died from homicide. That was her opinion. And that's why the indictment is charged like that, is because of how she was found. But that does not take away from what we have proven based on the testimony. And that is that she died from being murdered. That is called homicide. They're just going to charge you with the law of malice. It is not ill or hatred. It is just simply a killing without justification, excuse, or mitigation. It can be expressed, deliberate intention to unlawfully take the life of another person, and it may be implied with no considerable provocation appears in all the circumstances of the killing show an abandoned and malignant heart. I submit to you the facts and the circumstances of this case, and all the facts and circumstances of this case point to that conclusion as the only reasonable conclusion, that this defendant did in fact commit malice murder on the person of Melissa Walker. The state does not have to prove premeditation to prove murder, regardless of how briefly that malicious intent existed. Malice may be formed in an instant. And if malice was in the defendant's mind at the time of the killing or act, and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive needed for use to determine the defendant's state of mind at the time of killing, you are allowed to consider it, such as the evidence of domestic violence is lawful evidence of motive. Did he abuse her that year? Did he hit her? Did that happen multiple times that year? That's what the facts have shown. You can use that and those facts previously mentioned the fact that there's an open criminal case that she wasn't able to appear to. The fact that she was seeing someone else, the fact that she planned on leaving, that she had continually left him throughout that year. All of that is evidence of motive. Judge is also going to tell you that the testimony of the single witness, if believed, is sufficient to establish a fact. There's no legal requirement of corroboration of the witness, provided you find the evidence to be sufficient. That means that when you heard the testimony of Christina and you believed it, you don't need any corroboration for that to be a fact that you consider. That means if you heard the testimony of Christina and you believed her when she said that this defendant would always talk about going on a run, when you talk about, you know how to get rid of a body, who says that to his daughter, considering how her mother was found? That's after he says that after Melissa Wolfenbarger's remains had been identified. He makes those statements. That's what she remembers growing up. Does that? This defendant. This case went through several detectives that basically continued to work on this case. Detective Calhoun and Detective Shepard. Even through the retirement of Detective Calhoun, he continued to work with Detective Shepard until the cold case unit was created. And then 3 years later, you have this indictment. So from Detective Kelly, when we're talking about this skull is found, to the point where Norma Patton goes to Henry County, and Detective Stott really is the first investigator that starts to really investigate and look for Melissa as a missing person in Henry County. He wasn't able to get a lot of traction with the Atlanta Police Department at that point in '99. We have Detective Stott, who interviews the defendant. Back during that period, it's before 2003, he says, March, April, '99, last time he saw her alive. You have Detective Calhoun being assigned the case in 2003 when her remains are identified. And then when he retires, you have Detective Shepard, and he works with Stein to do some additional testing. And Detective Stott testified that he was one of the first persons to begin the missing persons investigation. And that's when the defendant, when we interviewed him, told him that the last time he saw Melissa was in March of '99. And we know that from the subsequent statement in 2021, when he met with Detective Shepard, that's not exactly what he said. He says, go around December of 1998. The only difference between when he makes that statement before 2003, that he saw her in '99 in March, and in 2021 is Melissa's remains have been identified. We know that the remains were located right by his job. And I submit to you that there's a reason why those two statements are inconsistent. That's his line. Detective Calhoun spoke with the defendant. Once the remains were identified, suspected the defendant once the remains were identified, and also began to look into the history. Because the first thing they do in homicide investigations, they look at what was the victim's life like. First thing he saw was, there's evidence of domestic violence. And what also stood out is the location of where Melissa's remains were found. We know that from the testimony, Melissa and Chris, the defendant, lived in this area by Brookline Street. We know that Action Labs is right here. And here's the junkyard. So we know that the head was across the street from Action Glass. And we know that the extremities are virtually right next door to Action Glass in this wooded area. So make no mistake, everyone's a suspect, but at this point, all of the evidence is pointing in this direction, this defendant. What is the evidence against this defendant? So there's a timeline of abuse in this case that was presented. We go back to the beginning of '98, you know, the testimony of China Patton that Melissa started working with her. It was a Virginia Highland Waffle House somewhere around the end of '97. So they were working together sometimes on the same shift at the beginning of '98. There was one point when China remembered seeing marks around the neck of Melissa Wolfenbarger. What she described appeared to show that marks of someone's hand around Melissa's neck. Immediately, the officer defendant went out to confront him. And that's when he got into the altercation with Troy Clinton. That's what you heard from the testimony team. And that's the beginning of 1998. And we get to July of '98. And so this is what Detective Calhoun is looking at as he's beginning to investigate the case. He's looking at the location of the remains and where they lived at, his job, and he's looking at all this information. All the evidence is pointing at this defendant. There's a police report that's created where the officer observes bruising and marks on the person, Ms. Wolfenbarger, Melissa. After that, he directs her. The defendant isn't there. He doesn't wait around. After that, he directs her to go toward him, take out a protective order, get you some protection from him. And that's exactly what she did. She went down there in person and applied for a protective order. So those are the records that Detective Calhoun had access to. This is the day after that July incident, July 21st. So the next day, July 22nd, she goes to the courthouse and petition her seeking relief from family violence from him. That's who she was seeking relief from. She was seeking relief from the choking that she had and her sister observed, that Troy fought him about. And we had that Rule 9 side setting it down from the 29th, and then we have that where the judge allows her to speak with this defendant. Just days after that, days after her hair is being dragged and pulled, days after she's been hit. And then that happens. It wasn't just what Tyner said. It wasn't just what Marlon Sutton said about what he observed. There's another person who saw that abuse. Dorothy Jones, Cooley Jones, Dorothy Cooley. She lived in that area. She'd known the defendant before she met Melissa. And remember seeing a day where Melissa had shades on and a black eye. When we talk about testimony of the domestic violence expert about humiliation, isn't that humiliating? Walking around and yet another bruise, another mark, another scratch. Sitting up here talking about skin conditions. That's not a skin condition, that's a black eye. You should be offended by them talking about skin conditions and trying to pawn that off as reasons why people saw marks on her. Tina didn't see a skin condition. These marks from this defendant's hand around her neck That wasn't a skin condition. That was bruising from being choked. The black eye wasn't a skin condition. He punched her in the eye. It's not a skin condition. Thomas Dixon. All the witness statements line up perfectly on top of each other. The witnesses that observed the abuse during this year. This is at the interview. So we go from 10 at the beginning of 1998. We go from Dorothy. We go to July, Officer 7. Then we get to the end of 98, and she's still being abused because she's still going back and forth between Dixon and this defendant. She's still talking about the abuse. This is at the end of the year. Last time he sees her is in December. She's being whooped, intimidated, coerced, bruised, punched, dragged down the street the entire year of 98. And I submit to you, that's not the first year it started. It didn't just start in 98. You can infer that this has been going on for a while, not just 98. Dixon confronted the defendant after he came to the Waffle House at the end of that year. You gotta leave. You gotta go. What did Dixon see? Them talking, Melissa crying. Kind of like that July 29th day at the courthouse. Them talking, Melissa crying. Then we got investigator over here. You heard testimony that from the mother. The DA's office went to interview the defendant's sister a year before that happened. He knew from that the DA's office was still conducting an active investigation into the death, murder, disappearance of his missing, murdered wife. So make no mistake about it. When they show up, that had already happened the year before. He knows exactly why the police are at the front of his house. Oh shit, it's his thing. He's hiding for 30, 40 minutes. Come out. He's right here. Let's see the video. There he is. Come on out, buddy. Gig is up. Yeah, 27 years. It's up. Hide it. And doesn't it look like what you saw? Doesn't it look like it was playing? It didn't look like it was just, oh, no. It looks like he planned to go there. Got there real quick, went out there, and sat out there for, I don't know, 10, 15 minutes. It's the police. Go hide. Guilty. Detective Shepard. You picked up this investigation. Had those same suspicions. Got home head. All the evidence is pointing to this defendant. But I'm going to interview Chris. See what he has to say. Let's see if his statements are consistent. Well, he admits to being fired because the Rock thought he stole the salt. Well, that's interesting. Admitted that he borrowed it. That's interesting. He admitted that him and Melissa were having problems. Admitted that Melissa was seeing and staying with a guy named Mike. Admitted that he did not look for his wife. Well, here's the thing. Even if he still has 2 young children, very young children. Even if him and Melissa had planned on going their separate ways, wouldn't you think that at some point he'd want to be able to tell his children that he would hurt their mother when you think at some point, for his children's sake, he would have tried to look for their mother? That is a fact I think you should consider, because he look at all those pictures of Six Flags. What is he trying to say? He's a good father? No, he's not. He's a little bit of mother. You can take your kids to Six Flags every day. That does not take away from the fact that you didn't do what you were supposed to do. One, you should have abused her. You should have intimidated her. You shouldn't have punched her. You shouldn't have grabbed her head and dragged her. You shouldn't have murdered her. That's kind of good father. And then you had that statement that he made, the detective Shepard, and I want you to hear this. So I'm going to take a moment to play it. I want you to hear this, what he says, those points in particular, what he says about the assault, what he says about his efforts to look for his wife, and what he says about his knowledge that she was going to leave him, the problems that they were having, and the knowledge that she had about Mr. Dixon.
That rate 60%. Connected to PHEPL 549022HEC and PHEPL 540039F10.
I mean, before that, I mean, where was she working? At that time, the wall, up in, like, she worked out in the middle of the corner. Where she worked? At the glass company, around the corner. All right, so when was the last time you saw Melissa? And that's the thing, you know, I don't quite remember if the last time was, because I remember, like, she would come and go, okay? And we say that it wasn't like we're happy-go-lucky. She's sitting right here one day and then she was up and gone. And I don't know if that's the way. So you kind of, would you describe your relationship as tumultuous or like on again, off again? You know, it was rocky there towards the end, mainly I think because it was her family so far trying to get back in her head and trying to make her think things and do things and like what? Man, she never had a relationship with her sister at all. You know, and then that towards the end, you know, I guess everybody has a need for one, you know, family and wants to love and want that type of thing. You know, and I think there towards the end, maybe she tried a little to try to get back with him or to do or what. But I don't think it was near what they made it seem like, that she was there all the time, or she leaving cards, pictures. And I know that did happen sometimes when she did, you know, at that time, but the struggle that we had, we had a common level of what we were trying to accomplish. You know, we had several goals in our, which was to go to California. This is a good way to get that and all. She was on my mom. She didn't want more than that. She didn't want her to be raised like she was in there. There was no, you know, we knew that her aims were bad and anybody feeling out there in the. Okay, so when was the last time you saw her? So the last actual time I remember was like, I woke up and she was gone. Like, we were in the middle of the night and she was left. And I don't know if that was the last time or the last time when I dropped her off at the train station to go to work. If it was exact. Do you remember telling Detective Calhoun that the last time you saw her, you were driving up to your house on Brookline and saw her walking down the street? And that was the last time you saw her. I don't know what they're saying now, but it's possible. Okay. I just don't. So that, basically, you said that was the last time you saw her, that she said she was going to the train station. Something to that effect. I'm not saying verbatim that's what you said, but it was something along those lines. It's possible. Okay. I'll give you that.
But does that sound like it's accurate?
Again, it could be. I don't know.
But you remember that incident, or can you recall that happening almost about to be home, driving up and her walking down the road? Does that ring any bells?
I mean, that's usually the way it happens because we only had one day. You know, if there was.
She would walk to the train station to try to go to work or something?
Yeah, or I give her a ride, or she, you know, sometimes she just wanted to walk. You know? Like, and we're not talking about like crazy from far away, we're talking about the people at the end of the road.
Yeah, I know, he's in the city, so I understand. But talking about that specifically, do you remember that day specifically?
I don't know.
Did you remember?
Why is that relevant?
Well, I would like to ask you, what was she wearing? Do you remember? Did she have a purse with her? You know? You know, the last time you saw her, when you came back home, she wasn't there. Where was her stuff? She didn't have a car. She couldn't move it, so it was still there in the house.
I don't understand. I mean, if she left it just like that, it was only like a small. I mean, kind of the same thing I did. I mean, when Austin Drive moved, my grandparents were going to sell the house and everything. You know, when I left, I didn't take hard enough. I don't go live alone. Whatever little.
After the last time you saw her, or that when she left, did she tell her family? Did she tell your family? Did you tell her that your wife left?
I mean, she had left many times before that. When she would leave me, I never knew that was the last time I was going to see her. If I did, I would have, you know, freaking kept her to her.
After that, like a month or two, you think that was.
You know, after a while, I was thinking that she was split and moved on. I mean, there was, you know, she was maybe seeing the guy and everything that was up there, or I know that she was living with in Buford, or no, I can't remember the last one was Buford or Peachtree Corners.
Was she seeing somebody?
I don't know if she was seeing somebody, but there was this dude, and I want to say his girlfriend, that sometimes that she would stay with him in like an tiny lodge out that way.
And how did she know this?
She worked with him.
Was it the girl or the guy?
I want to say the guy and the girl both worked there, but I could be wrong. I know the guy worked there, but I know that it was a couple, you know, because then there was this one time that they had called me and said that they were moving and she had to go do something. You know, she had to do something else.
This was before the last time you saw her, right?
Well, that's
what I'm saying. I'm just wondering.
all that was.
I'm not misunderstanding you.
Right.
I'm not trying to trick you or confuse you.
No,
I just want you to remember.
I'm trying to figure it out.
Like, if you were there, I was, so that's fine. I'll tell you about it. I don't know. I just want you to be accurate. All right, so year goes by, you still don't tell anybody that she's gone.
I mean, I'm figuring that she's already done. I mean, we were always talking about changing it and doing all, and she had the stuff there.
Right.
You know, she got to the point where she was unhappy with me. I'm not trying to push myself in anybody's life that doesn't want me there. I mean, I look at my daughter and everything that's going on there. I've been trying to push. And, you know, looking back at this thing now, I was wrong. All the way around with both of them. Maybe I should try to push forward and try to do it. But
You said you lost your job back then. What the job you last time? Why did you lose your job?
man, this guy, now, there's a lot of things going on right there with that. But, and I do now the same thing pretty much I did then. I mean, I work on local players and things on the side. And there was a guy that I don't know who stole things. There was a saw that was missing. And I can tell you the exact guy that I borrowed this tool from and everything too. I didn't steal their saw. Period.
Why did I?
Because he said I stole a saw. Because the saw was missing. And I lived out of the corner and he drove past my house and he seen the back of the book player right there at the top was cut off.
So he thought you could cut something off the car.
You know, and I thought, look, I don't know anything about it. You know, and then there was that, and then there was something where I drove through the toll plaza thing on 400. You know, there were just a bunch of little things that was just last straw.
You need to go through the whole process.
You know, there used to be a thing where you can go in and go through it.
Right.
You know, and I was under the understanding, I was under the understanding that, you know, the thing was painful, or there was just a bunch of little things. And that was just last straw. There was no big deal, there was no,
It's what you go.
right,
They file and so on.
yeah. Well, we had to do it, and, you know, if that comes everywhere, I've always thought I tried to tell them whatever, but I just said the last straw, yeah.
Did you ever go up to the Waffle House and get an altercation with males there?
I don't remember, I saw that on the internet, I don't remember that.
Guys, you came up there and beat you up.
And it seems like I would remember that, but I don't, you know,
You drive a yellow Volkswagen?
I never had yellow, no,
What?
what?
It's never yellow.
Never, no, I've never had yellow, I had a thing against yellow cars.
What do you think happened to it?
Man, every which way I think about it, it has to go back. If her parents didn't do it directly, it had to be something indirectly around them. I beat my brain.
So when you found out that a body was found just around the corner from where you were, and that the body has been dismembered with assault,
I didn't know that the body was dismembered with assault at all.
you know the body was dismembered?
I heard that. Nobody ever said assault. I didn't hear about that. Nobody ever gave me an autopsy. Nobody said that to me. I didn't know that until on the internet. Honest to God, I mean.
So what motive would her family have to kill?
I mean, to me, it sounds strange that they got away with this stuff for all these years, and then all of a sudden, right, as we split up and doing it right there, and all of a sudden he ended up guilty. I don't know if she came to them needing money, or,
Do you think it's likely that her own family murdered her up and cut her up?
man, her own family killed her family and friends.
Yeah, I know he committed murder, but that's.
So his family and friends.
Why would he kill her? What would be the motive to
Hey,
that?
man,
He's involved in, your family's involved in criminality, and you're trying to protect yourself from going to jail. That's a motive to kill someone. What motive would he have to kill her?
well, we knew what he did. Her dad was like her mom.
So you weren't worried about him coming after you? I mean, he's gonna cut up his own daughter and cut you up.
Oh, when he come after me, I didn't do anything. I didn't come in, here's what I'm saying, okay? I don't know if she needed money, or it may have come to him and threatened him in some way, and, you know, and they did it, maybe they were drunk, it's one thing that I don't know, but anything I say at this point is speculation, because I don't know. But I feel like the hell, if they're serial killers, they have killed their family and friends, and something happens to their family. Okay, first of all,
Serial killers operate those kind of. Okay.
let's say what this, okay?
Well, I'm not here to talk about, I'll deal with their family. and
Right.
speculation.
Let's look at the facts. Facts, you said that she was put in bags, right? Well, that's what's on the internet, that she was in a lot.
I didn't say that.
So was she put in bags?
Well, I didn't say that.
No, look, we're being straight. I'm trying to help you out. I'm trying to
What
figure
I
this out.
understand, the body parts had washed out of an area onto the street. Now, there were bags recovered there, so to make the assumption that they may have been in bags, yes. But I wasn't there to see, so I can't.
Nobody has been straight up with me on this, okay? And everything that I'm learning is basically through the internet. And we all know how the internet lies, and it's a whole
I
thing.
agree 100%.
Everything that the internet says about me, living under a different name, trying to hide, and it's all deadly lie.
That's why I'm not asking you about that, because I'm not going to go off on speculation from the internet.
Throughout the trial, you heard from the testimony of Dr. Rosa James. She was domestic violence expert. She had hundreds of experiences with persons that have been victims and perpetrators of domestic violence. She was able to tell you about some of the cycles of abuse, talking about tension building, the beginning of 1998. We talked about the incident, the different phases where there's an incident, then there's a reconciliation, and then there's calm. And so ultimately, what we have from the beginning of 1998, when Melissa started working with her sister, we have a representation of what that expert was talking about. We have the tensions, we have the incident, we have the reconciliation, I'll call that July 29th, and then we have the subsequent calm until we have the disappearance of Melissa. And I would submit to you that testimony of the expert, of Dr. James, is relevant testimony, is testimony you can and should consider in evaluating what's been presented in evidence of domestic violence. And I would ask you to put the appropriate weight on her testimony and use that in the determination. Dr. Mark Gilbo is an anthropologist with a specialization in skeletal remains and analysis of skeletal remains. He was able to say he observed saw marks on the remains of Melissa Wolfenbarger. And as far as the exhibits that he was able to go over, exhibit 34, which you'll have, you see the example here where he's talking about part of the bone that has been shaved down. And you have the next exhibit, the autopsy of the remains of Melissa Wolfenbarger. You see where the saw marks are that were indicated by Dr. Gilbo, what he observed. And then you have the ridges here, where it also appears that there's some type of mechanical saw or device that is being used to dismember the remains of Melissa Wolfenbarger. I'll submit to you, those are facts and evidence, along with the fact that this defendant was in possession of the saw, the fact that this defendant borrowed the saw from his job, the fact that this job never got the saw back. Those are all facts to be considered. Those are all logical, common sense deductions that you can draw. But then the testimony of Dr. Cherry. You heard about the analysis and testing, in particular by the swabbing of Norma's mouth, the analysis of the dental records, and that ties directly into the additional analysis and tests that Detective Stein did, and he documented Detective Shepard. And we have that additional testing where, even though it didn't result in anything useful, Detective Stein was able to retrieve the bags and submit them for additional testing. And I submit to you that those bags were outside for who knows how long. I submit to you that there was evidence that the head had been moved. I submit to you that George McEachran encountered that bag along with his daughter. I submit to you that Tina Miller, Fulton County Medical Examiner's Office, responded to that location along with Detective Kelly and the Atlanta Police Department. And even though that did not result in useful information, the process is important because it's important to cross every T and dot every I. And in this investigation, that's a part of the process, and I submit that to you. And at this point, ladies and gentlemen, I'm going to sit down. The defense will have opportunity to address you with their arguments. I will submit to you that this case is not about the family of Melissa Wolfenbarger. This case is about the tumultuous relationship between this defendant and our victim, Melissa. He wasn't able to control her, and when he lost control, he murdered her. That's what the evidence has shown. And at the conclusion of the case, after the judge charges you on the law, I'm going to ask you to vote the truth, and that's guilty on that count of murder. Yes, sir.
Thank you. Mr. McDermott, does the defense wish to make a closing statement?
Yes,
Closing
Your Honor.
argument? Thank you.
state gets to split their argument. So they'll make an argument, I get to make an argument, they get the last word too. Okay, first word, last word, and I won't get to rebut that. That's just the way it is. We accept that. You've all taken an oath, and you've taken an oath. The judge will instruct you in just a minute. Not my words, not their words. The law that will require you to decide this case based on evidence. Based on evidence. You remember in my opening statement, I told you that the state has got gaping holes in its case. And that the state is going to give you bits and pieces of evidence. And then it is going to tell you a story to fill those in the way that suits them. And it's going to ask you to imagine along with them that that story is true. And it's going to ask you to make a leap of logic at the end of it. From alleged instances of abuse to murder. And I have asked you to follow your oath, to follow the law, and decide the case based on the evidence, not on the imagination. Let's talk about the evidence a little bit. You've been told about the difference between direct evidence and circumstantial evidence. I won't rehearse the story, the lesson. What hard evidence exists in this case? I will submit to you that not one bit of direct evidence in this case points to that man right there. Not one. I'm not saying there's no direct evidence in this case. There's lots of it. There is obviously the remains. There is the manner in which those remains were recovered. We had the head discovered in the street on April 29th. We're not exactly sure how it got there. One detective thinks there was a great rain event that washed it out. Another one says there was a dog. We don't know. And then about a month later or so, they discovered several bags in the wooded lot behind the trucking business. Some people call it a junkyard. Come back to that. The medical examiner eventually is able to identify the skull using dental records, dental charts. And notes that there are tool marks, of course, on the body parts. After some time goes by, we also know that there was a search at Christopher's former residence. There was lots of evidence taken from this. Lots of evidence that came from the remains. As we talked about before, there were paint chips in the hair. There were human hairs, apparently not Melissa's. There were pubic hairs, a pubic hair. There was DNA evidence. There were carpet fibers. There's lots of evidence. And you heard the detectives sit there and tell you, we specifically sent this off for testing. Some of it more than once. Whoever's hair that was in there that wasn't Melissa's was also not his. Whoever's pubic hair that was also not his. Wherever those paint chips came from, it was not from his residence. Someone says, oh, it was remodeled. It may have been remodeled, but folks, when you paint over paint, the old paint's still under there. You go scrape a paint sample, you're going to get all of it. None of it matched. There was luminol evidence. It sprayed the entire house, not a drop. And finally, the more modern DNA taken from the bag. You heard Detective Stein sit there and talk about the event where they went out with all the media to the site, looked at the proximity to where Christopher had worked. You heard him testify about the DNA in the bags, and he read the results of those reports. Yes, we found DNA. Yes, there was a viable profile that represented 5 people. Two of whom at least were male. And they submitted Christopher's DNA sample. They went up specifically again to get new DNA from him and submit it for that test. That was in 2022 or so. Christopher willingly submitted. Yeah, he knew the DAs were still investigating him. He didn't run from it when they called him and said, hey, we'd like to get your DNA. And he submits it, and you heard the results of the test. Christopher Wolfenbarger is excluded from being a contributor. Well, that's when we hear this theory about there was a great rain flood event. I gave this page from the weather reports. The National Climatic Data Center for the city of Atlanta in April of 1999. I gave it to Detective Shepard. And you saw him pretend he couldn't. Or I believe it was done, I gave it to him. And you saw him pretend, oh, I'm not comfortable reading this. This document's going to go back with you into evidence. And you all can look at it. And if there's a single one of you who can't figure it out, I will be shocked. The days go down here, the days of the month, the hours of the day go this way, and at the end, there's a cumulative total of the rainfall for each day. And you'll be able to look at this document and see that on that day, the other deputy who said there was an intermittent mist was correct. There was roughly 1/4 of an inch of rain for the entire day. And most of it appears to have fallen at about 3 o'clock in the morning, long before that had appeared on the road that day. And you can look up the rest of the way, 0.000000000. Detective Shepard, oh, it rained so much that month. No, it didn't. They analyzed the carpet fibers, they could find no match in Christopher's house. So then we're told about the circumstantial evidence. It's interesting to me that you just heard the district attorney tell you all the facts and evidence in this case point to one man. But he's not talking about this hard evidence, is he? Because there's a bunch of that and not a single bit of it points to this man. All of it points away from this man. But Detective Shepard, or maybe it was Detective Calhoun, one of the two, got on the stand and said, there's only been one suspect in this case from day one. Well, when the results keep pointing away and pointing away and pointing away, maybe there should have been a difference. Maybe you should have asked some more questions of the neighbors or of the family. You heard the detective, the district attorney here tell you. That's how we conduct investigations. We look at the person's life. We want to find out what's going on in their life. They never investigated that family. They never investigated anybody else. Where are the records of the test of paint chips for a single other person's house? Where are the records for a search warrant from a single other individual's house? Where are the search warrants getting hair or pubic hair or DNA from anybody else in this investigation? Crickets. because they want to tell you a story about domestic violence. I'm a supporter of Me Too. Domestic violence is a real thing. You've heard the district attorney tell you multiple times now, this is a case about domestic violence. It may have that question in it somehow. Certainly it does. It is an issue you're going to have to decide. You're going to have to decide how much weight to attribute to those alleged incidents. And you're going to have to decide, as a fact finder and determiner in this case, how it fits into the overall picture. But this is not a case about domestic violence. This is a case in which a man is charged with an act of murder. And the state has not given you one single instance or bit of evidence about an act of murder. They want to get you sympathetically on the board after he tells you, don't judge this by sympathy. But then he wants to tell you all these violent instances. He wants to embellish them. He punched her. That's not an evidence anywhere. He beat her all the time for the whole year. That's not an evidence anywhere. And they want to tell you that story and then ask you to make the leap to there must have been some act of murder also. What about these instances of domestic violence? We heard from first about the July 1998 incident. Yes, there's a police report. We had a police officer testify. He told you he did not look under her clothing. How could he have known if there were scrapes on her back or backside? He told you that. I didn't look at that. We get home and Norma says, well, I got home with her and she had scrapes all down her backside. Just after she had gotten done telling me that she was wearing blue jeans. I'm not sure how you get scrapes if you fall on the ground with blue jeans on. You have reports from Tina. Tina says she came in there with choke marks on her neck. And there was another guy named Clinton who stood up for her. None of that story is corroborated by anybody else anywhere. The only person who's ever told that story is Tina Patton. Tina says she took Melissa back up to Chris's house on Brookline and confronted Christopher. But Christopher tells Detective Scott in his interview that he didn't like Melissa staying with her sister, because she got her into cigarettes and also was doing meth. Not necessarily that Melissa was doing it, but that he didn't like Melissa around that stuff. Well, I think there would be a confrontation when she brought her up there. We've heard from Mr. Dixon about domestic violence. It is funny to me. You should find it incredible that when he gives an interview in 2003 to the police about Melissa, he does not one time mention abuse, marks on her body, being drugged on the sidewalk, her complaining about her husband. He does not mention it one single time in an hours-long interview. And suddenly, when they find him at the last minute before trial, they find out he's been watching true crime shows about this, and suddenly he remembers this incident where she had bruises and she was drugged on the sidewalk. The testimony is not credible from the former Waffle House employee and bank robber, Mr. Dixon. You heard evidence from Miss Cooley. Lived across the street. She seemed to be confused about a lot of her facts and details. Testimony was difficult to follow. But she says, oh yeah, I heard screaming and breaking glass over there all the time. There was apparently no glass left in the house at some point. Definitely from that house. Definitely that house where Chris lived. And I know that because that's the house I went in and cleaned. I cleaned all the houses that Mr. Holyfield owned. Who's Mr. Holyfield? Holyfield didn't own that house. You heard testimony from several people. That house was owned by Christopher's parents. Miss Cooley was never in there. I think Miss Cooley's confused as to what she's talking about. Well, I definitely saw a black eye behind the glasses. And then she said a few moments later, I only saw her passing a few times when she was getting in the car to go to the grocery store. Never talked to her, just said hi. Testimony about Saul. Oh, he had access to Saul's home. Well, their memory seems to be just as cloudy and hazy as a lot of people. And this is a 26-year-old case, that's understandable. But I look at the statements that were made, and I see at least 4 different versions of that story that were told. In the original detectives' reports, they said a Saul went missing while Chris worked there. And we thought it was Chris. We blamed Chris. And we never found him. And then later it turned into he stole a saw. And then later they backed off and said, well, no, he asked to borrow a saw, and we never gave it back. You heard them, their own witness, they had to impeach you by playing things that were in audio because they said they didn't even remember saying that. And they testified here that he took a saw, not saying he stole it, whatever. And she didn't even remember talking to me a couple weeks before that, before trial. She didn't remember telling me on the phone that, yeah, he brought it back. My apologies. Circumstantial evidence about alleged conflicts in Christopher's statement. What conflict did you hear in his statement? Inconsistencies, that was the word. There were inconsistencies in Christopher's interviews. And they played for you the interview with Mr. Stott, 2001. And then they played for you the interview with Detective Shepard in 2021. In one version of those stories, in the 2001 interview, Chris tells that the last time he ever saw Melissa, she was walking down Lee Street by the MARTA station. And he stopped to pick her up, took her up the road to Taco Bell, right by the interstate. And when they were done talking, apparently she talked about wanting to get back together. He said that was too emotional for him at this point, and he dropped her off back at the train station. And she left back north. Lee Street, MARTA station. How far is that from Christopher's house? Because when these
myself. So those are the closing arguments for the state and also the defense. Guys, what do you think? I don't think they're going to have enough. Y'all know we do have our TiVo time, which is awesome, right? No, we don't. We out of TiVo time. We don't have no TiVo time. So I guess they'll be coming back for lunch and giving us jury instructions and getting it over to the jury. Let's see here. I'm like, why is it so dark over here? Now I know why it's so dark over here. Of course. Okay, so what we're going to do here, is there any testimony that you guys want to relook at in regards to Christopher's case? Or we can rewind and kind of go back and look at our closing argument. Oh, you know what I can do here? Because I think a lot of people missed out on a lot of this portion. Let's go back and listen to our girl that took this. No. You know, I found yesterday when I was looking at the reviews and the clips of everything, I did notice how, you know, the prosecution yesterday did a pretty good job with those witnesses that the defense did call to the stand in regards to the mom and the sister. Remember, they were even actually able to impeach her a little bit in regards to those letters. So let's look at that and then review that again, because I think that could be like their witnesses backfire, and then it's vice versa for the prosecution. Their witnesses backfire. Like everybody's witnesses is backfiring on them in this case. But of course, the prosecution team did put up way more witnesses that had issues than the defense would have ever put up. Let's see here. I am going to get that queued up while they are currently on their break. I don't even know if, I guess maybe the jury will have time to deliberate. They may just be able to go back there and pick a four-person. We know that count 2 went to a direct verdict, so that won't go to the jury. It appears that the judge has voted on that part, and we can kind of listen to that portion too. So let me get that queued up for us. Mm-hmm. We got an update in that Ashley Elkins, that trial. We'll look at that a little bit later too. That should be interesting.
Cameron, KIMBERLYCAMBRON.
Okay, and also we will remind you to try to talk more slowly because the court reporter needs to take down everything you say. And I will add a caution the judge has given other witnesses that there's a ledge right by your chair, so be careful not to roll off to the side too much.
That is true.
All right. Now, Ms. Cameron, do you know the defendant?
I do.
How do you know him?
It's my brother.
And did you know Melissa Wolfenbarger?
Yes.
And how did you know her?
She was married to my brother.
Okay. And did you know her while she was alive?
I did.
Did you spend time around her?
Yes.
Okay. And how and where did you spend time around her?
When they were married, they lived with my grandmother. So I would go there and spend time with her.
And would you do that frequently?
Yes.
So you suffice it to say you spent quite a bit of time around Melissa.
Yes.
Okay. Do you remember any episodes growing up with her that stick out in your mind?
Yes. I remember when I was learning to drive, I was so nervous that every time I would drive, I would go over to the side of the road.
You would pull over?
Well, when a car was coming toward me, I was afraid that I was going to hit that car. And so I would pull over and she would calm me down.
Okay. Do you remember when Melissa was pregnant?
Yes.
With Chrissy?
Yes.
And then about a year later with Joey?
Yes.
And do you remember her having discussions about the custody of those children?
I do.
And do you remember what she ultimately chose as far as a decision in that regard?
She decided to give custody to my mom.
And why did she discuss her other parents?
She did, and she said that she did not want her mother or the state to have her children.
Did she at any time give you a reason why she didn't want her children with her parents?
She did. She just, she did not elaborate. She just said that they were not good people.
Okay. You said you visited Melissa multiple times because she lived at your grandparents' house, correct?
Correct.
And you went over there multiple times. Were you generally over there during the holidays?
Yes.
Was it pretty much every holiday?
Yes.
Do you remember, you spent most of the holidays with Melissa then, correct?
Correct.
Do you remember if Melissa at any time called her mother on a holiday?
Not to my knowledge.
Do you remember her calling her mother at any time?
Not to my knowledge, no.
Do you remember her writing letters or cards to her parents?
No, not to my knowledge.
Just a minute, Your Honor.
Sure.
No further questions, Your Honor.
Thank you. Questions for this witness? Yes.
Good morning, Ms. Cameron. How are you?
Good morning, good, and you?
I'm doing well. Thank you for asking. You just testified that Melissa told you she did not want her parents to have her children. Is that fair?
Yes.
Okay. What year was this? Do you remember having these conversations with Melissa?
I don't remember it exactly, but it was between 96-ish.
Okay, 96-ish. All right. Permission to approach, Your Honor? Sure. I'm going to approach with what's been admitted as exhibit number 71. And I want you to read this entire letter out loud, State's exhibit number 71.
Dear Mom, hello. It's been a while since that.
Hang on, sorry, yeah. If you would just try and read it a little bit slowly, especially when we're reading things, we have a tendency to speed up. And again, the court reporter has to take it down, okay? Thank you.
Dear Mom, hello. It's been a while since that weekend that I last talked to you. I thought that I would write you a letter. I'm okay. Here are some pictures of Chrissy, 7.5 months. Can you, I'm not sure what that one says. Please.
Does it say you can pass them out?
Yes, sorry. You can pass them out if you wish, but it won't. For
Does it
the
say, but
fact,
if it wasn't for the fact that Kathy was there when I got them, she would not have gotten any.
she would not have gotten any of them. She wanted me to give Chris's grandmother the biggest one, but I didn't. And she got mad at me, but oh well. They are both getting on my nerves. They act as if Chrissy is their daughter and not mine. And there is something that I need to tell you, and I really don't know how. So I will tell you like this. And do you want me to continue?
Yes, please.
You will sooner than you think have another grandchild. July 27th is the due date. Do not be mad because you are not the only one just finding out. Please. Not sure.
Does it say, please don't rub it in, mentioning something like, you know, how hard it is to take care of two kids so close in age, like Kimberly and JC.
A few days.
Is that
Other girl. No names have been picked out yet, and I know not what to expect at baby shower, so I won't ask, but feel free. And with this one, I plan to let you have a part of his or her life who says Chris has to know, and when we move, we will do the same to Kathy and family that Chris did to you and Dad. No part in Chrissy and baby's life. Chris don't like you. Well, I don't like Kathy or Virginia, but Kimberly and I get along pretty good. Every time she hears her mom say something about me, she sticks up for me and tells me about it. I remember telling that Kathy said that she wishes me and Chris would move away. Kimberly says to her that if she moves, that Chrissy would move with us. Kathy said no, she won't either. And Kimberly, she is their daughter. Then Kathy said no, she isn't. If someone said that about you would be mad. So did I told Chris, and Chris got mad. When Kathy asked to take Chrissy off, Chris said no, she'd better be here when I get back. And Kathy got mad, and I laughed. You probably think this is stupid, but if you had someone trying to be mother to your daughter, you would get mad too. And when we do move, they are not going to know where we are living. In free time, they go off. They have to take Chrissy and don't even ask. They get her all ready and leave. I'm supposed to have my own car soon. Then I will bring Chrissy and let you see her. Bye for now, Melissa.
And this is a letter that Chrissy wrote to her mother. Is that fair to say from what you read?
I'm sorry, could you repeat the question?
Sure. Does it appear from what you read that's a letter that Chrissy wrote to her mother?
This is a letter that Chrissy wrote to her mother?
A letter that Melissa wrote to her mother.
In my opinion, it doesn't sound like Melissa, but it does state her name on there.
And it's signed by her?
Yes. It says bye for now, Melissa.
And so in that letter, Melissa actually wanted her mother to at least spend time with her children. Is that fair to say?
In that letter.
And is it fair to say that she actually would have preferred her mother to have her children rather than Kathy, who's your mother? Is that fair to say?
Again, in that letter.
Now, you also, I think, discussed on direct examination that you were not aware of any cards that Melissa sent to her mother?
You have to answer out loud. Thank you.
Permission to approach?
Go ahead.
I'm going to show you what's already been admitted. That states exhibit 67, 68, 69, and 70. You take a moment to look at those. And I'm going to So I want to first look at state exhibit 67. Is this a letter addressed to Norma Patton?
Yes.
And is your understanding Norma Patton is Melissa's mother?
Yes.
And does it say birthday?
Yes.
And does that say happy birthday?
Yes.
In 97 with an asterisk?
Yes.
And does it say love you, Chrissy and Joey?
Yes.
And it's Chrissy and Joey, Melissa and Chrissy's children?
Yes.
Looking at State's Exhibit 68, is that addressed to Carl and Norma Patton?
Yes.
Right. And does it say anniversary?
Yes.
And does it say Melissa Wolfenbarger at the top?
Yes.
And is Melissa their daughter?
Yes.
And does this letter or card say on side special anniversary, which is to a very special couple? Have a happy anniversary. Love, Melissa, Chrissy, and Joey.
Yes.
And does it read in handwriting, happy anniversary. This year, I am going to take you out to lunch. My only day off is June 6th. Meet us there at 11:45 to 12 at Ryan's. You and Dad can bring JC and Kimberly.
Yes.
Does this appear to be a letter or a card sent by Melissa to her parents for their anniversary?
Yes, it appears to be.
Now showing you State's Exhibit 69. Is this appears to be a Father's Day card?
Yes.
Does it say for a dad who means so much?
Yes.
It means so much to know our family can always depend on you.
Yes.
Have a very happy Father's Day.
Yes.
Love, Melissa.
Yes.
Does the card further read, Dad, with all the things you have to take care of, you always take care of your family first.
Yes.
And on a bag, does it say, a father's love is a promise made deep in the heart of a man, a promise to care for his family that keeps every day of his life.
Yes.
Is this also signed by Melissa?
Yes.
And was it sent to her father, Carl Patton?
Yes.
State's Exhibit number 7. Is this a Mother's Day card?
It says Mother's Day, yes.
Does it say, is it addressed to Norma Patton?
Yes.
Does the card read, it is the only thing in the house that doesn't have to be swept, polished, watered, cooked, picked up after, or washed behind the ears. Relax and have a happy Mother's Day, Melissa.
Yes.
And right, appears in handwriting. Next Wednesday, May 14th, I would like to take you and Daddy out for lunch. I'll give you your Mother's Day present then.
Yes.
And these all appear to be cards either from Melissa or Melissa writing cards on behalf of Chrissy and Joey. Is that fair to say?
That's what it appears.
Now, you testified on direct examination that Melissa and Chris lived with your grandmother.
Yes.
If you can approximate, when did they live with your grandmother?
I don't remember the exact time.
At any point, did they move from your grandmother's house to a different location?
Yes.
Where did they move to?
They moved to Atlanta.
Do you know where in Atlanta?
I don't recall exactly. I think Brookline Street.
Okay. Now, Brookline Street, are those homes that were owned by your grandmother?
Yes.
Had you ever visited Melissa and Chris at the Brookline address?
I'm sure I have, yes.
Do you think you spent more time with Melissa and Chris when they were living with your grandmother or when they were living at the Brookline house?
I think it was more with my grandmother. I can't remember.
Now, you talked about your kind of relationship with Melissa. Would you consider yourself friends?
Yes.
Did she speak to you about her life experiences?
I'm sure she did.
Did she talk to you about your brother?
I don't remember.
Did she ever discuss to you some of the difficulties she was having with her brother, with your brother, excuse me?
No, I don't remember.
Did she ever talk to you about her and your brother arguing?
No, I don't remember.
You don't remember, okay. What about them fighting? Did she ever talk to you about that?
No, I don't remember.
Did she ever talk to you about a July 1998 incident in which your brother pulled her hair and dragged her down the street?
No.
No, or you don't remember?
No, I don't remember.
Do you know if she talked to you about the fact that your brother, was upset because she went to the male neighbor's house who was up the street?
No.
No, or you don't remember?
No, I never had that conversation.
Okay. Do you recall her ever telling you that she loved your brother, but she wanted to leave him?
No,
No, you don't remember? No, it didn't happen.
no, I don't remember.
Do you remember detectives back in around 2003 coming to meet with you regarding Melissa's disappearance?
Yes,
And do you remember it being a Detective Calhoun?
I don't remember who it was.
Do you remember talking to him about your friendship with Melissa?
I don't remember exactly, no.
I'm sorry, say that last part again.
No, I don't remember.
Okay. And I apologize. Do you remember talking on the phone with any detectives back in 2003?
No, I don't remember talking on the phone.
Did you tell that detective that Melissa wrote you a letter?
No, I've never said she's written me a letter.
So is it your testimony today that you never told a detective that Melissa wrote you a letter prior to her disappearance?
It is my testimony that she did not write me a letter.
And that you never told a detective?
I never told a detective that she wrote me a letter.
And that in the letter or either in a conversation, again, Melissa told you she loved your brother, but she was getting ready to leave him.
She's never told me that.
Do you remember Melissa telling you about a guy that she met at the Waffle House?
No.
And do you remember telling any of that to a detective over the phone in 2003?
I never said that. I didn't on the phone, no. Never.
Your mom, Kathy Wolfenbarger, she raised Melissa and Chris's children.
Yes,
Is it fair to say that your mother never talked about Melissa to her children after she disappeared?
can you rephrase that?
Sure. Is it fair to say that your mom did not speak about Melissa to her children after Melissa disappeared?
I don't know.
You don't know? Is it fair to say that your brother did not speak about Melissa to their children after Melissa disappeared?
I don't remember. But they did take the children to Melissa's funeral, so I'm sure at some point they did talk to her, both of the children, because they were younger.
Would you agree with me that the funeral was in 2003?
I don't remember exactly when it was.
Let's speak about the funeral. At the funeral, did you know that Kathy and Chris didn't tell the children that it was an actual funeral?
I don't know.
Did you know that Chris nor Kathy actually wanted to go to the funeral?
I don't remember what their feelings were.
Let me ask, when the kids were younger, did you ever talk to the children about Melissa, your friend?
I don't remember exactly.
Do you remember ever telling the kids that Melissa was their mother and she disappeared?
I don't remember how and what was discussed.
Do you ever remember showing the kids pictures of Melissa?
I don't remember.
Now, in 1996, is it fair that Christina gave temporary guardianship to your mother?
Yes.
I'm sorry, was that a yes?
Yes.
Thank you. That's okay.
And Your Honor, this time, the state is going to ask to admit State's Exhibit 81 and 82, which are self-authenticating documents from the Henry County Probate Court regarding the guardianship of both Christina Wolfenbarger and Joseph Wolfenbarger.
Mr. McDermott,
No objection.
81 and 82 are admitted.
Thank you, Your Honor. Did you know, or do you know, if on July 23rd, 1998, Melissa dissolved that temporary guardianship?
I don't know.
Well, first show you State's Exhibits 81. And on State's Exhibit 81, am I showing you this document?
Yes.
And does this document read on the page that's clipped, in the matter of Christina Wolfenbarger, petition to terminate temporary guardianship of minor?
Yes.
And does it say the petition of Melissa Wolfenbarger shows, one, petitioner is the natural as mother and father of the above named minor? Does it say that?
Yes.
And does it say that on 8/28/96, the court appointed Kathy Wolfenbarger as temporary guardian
Yes.
of the above named petitioner and temporarily relinquished parental rights?
Yes.
And then it says, wherefore petitioner prays that the court enter an order dissolving the temporary guardianship instant term.
Yes.
Okay, and has her signing, it looks like Melissa's signature, or a signature, I should say.
Yes.
Okay. And is the date of this July 23rd, 1998?
Yes.
Did you know that that is 2 days after Melissa called the police on your brother?
No, I didn't know.
And you also see in State's Exhibit 82, the same document, petition to terminate temporary guardianship of a minor. And it's the same document for Joseph.
Yes.
And is that also on the 23rd of July, 1998?
Yes.
And were you aware that about a week later, on July 29th, 1998, Melissa then asked for permanent guardianship, or gave your mother permanent guardianship of the kids about 2 weeks later?
Yeah, I don't know from the documents, yes, but.
And let me ask you this, did you know that on the day that she gave permanent guardianship was the same day she dropped the temporary protective order that she took out of control?
I don't know.
How would you describe Melissa's demeanor?
I would say she was quiet.
Was she easily influenced by?
I take us into the jury instructions. It looks like they do have the instructions out. I might be confusing myself. That's not good, huh? Let me go ahead and share. And we'll go through the jury instructions. I don't know. I I think it might have fast forwarded on me. But let's go to. It looks like Simone did the rebuttal. Ms. Hilton. Like I'm up here rewatching stuff for no reason. That's all. Let me get that up here for us. Share.
I'm the last voice that you're gonna hear for the city. And we get the opportunity to speak to you last because we have a burden. And in this case, we have waited 27 years to get justice for us. And at this point, ladies and gentlemen, we have proven that this defendant killed Melissa Wolfenbarger sometime in late 1998 or early of March 1999 for no other reason except for jealousy, anger, and the fact that he was about to lose control over this woman who he had for 7 years. And I'm going to ask you all to bear with me for a few moments as I tell you and show you how we've proved this case beyond a reasonable doubt. Now, as Mr. McDermott was speaking, I'm reminded of two things. One, what I was told in law school, that when you have the law on your side, you argue the law. When you have the facts on your side, you argue the facts. When you have both, you argue both. And when you have nothing, you just argue. And that's what Mr. McDermott did for about 45 minutes. Now, I like Mr. McDermott, but he was given a tough case. And because of the case that he was given, he just had to argue to you for the last 45 minutes. And I'm going to show you how everything that he said makes no reasonable sense. Because what we ask you as jurors is that you have to make reasonable inferences based on your common sense and reason. We ask you not to leave your common sense at the door, but you bring it into the courtroom. And there's only one reasonable conclusion in this case. And all roads, all logical roads, all roads lead to one defendant, and that is him over there. I'm then reminded of a second story. Story that I've been told a long time ago regarding a red light. And the story goes that there was a man coming across the border, and he had a red light. And every day he would come cross the border with a red light, and it had a basket with sand. And every day as he came across the border patrol guy would say, look in the basket and say, what's in here? There's something in here. Every day the guy would come and say, nope, there's nothing in there. Ride his bike every day, having for a substantially long time. Then one day, the border patrol guy and the man on the bike was at a bar. The border patrol guy was ready to retire, and he speaks to the man and says, you know, all those days and all those years you were riding this bike across the border. And every day I looked, and there was nothing in the basket. What were you doing? God says nothing. Congratulations on your retirement. The night keeps on going, and they're drinking a little. And the border patrol goes and says, you know what, I'm a little drunk, I'm not gonna remember what you tell me. So tell me what you were doing. He said, no, don't worry about it. Here's another drink. And drink. It's now the end of the night. Border Patrol was like, look, I'm getting ready to go home. I've been drinking a lot. I'm not going to remember what you told me. Tell me what you did. He said, you know what? I'm going to tell you. He said, you know, every day when I was coming through with the red bike, you were so focused on what was in the basket. But I was smuggling in a new red bike every single day. But because you were focused on what was in the basket, you were missing what was right in front of you. And what the defense counsel has asked you all to do is focus on all these reasonable theories. And we're going to talk about these reasonable theories in a moment. And not focus on the path that's right in front of you. And like I said to you before, the path that's right in front of you leads straight to the Wolfenbarger. Straight. So let's talk about some sand in the box, the basket. Let's talk about it. First, no physical evidence. That's the first thing, right? You talked about the paint chips. So let's talk about when they went to the house. They went to the house in 2003. What happened in 2003? What do we know? Well, what we know from Dorothy is that he abruptly left in February, sometime in 1999. He didn't tell his friends he was leaving. He didn't tell his Dorothy, the person he would hang around with every day. He left all the clothes in the house. And what did Dorothy tell you? She had to come and clean it out. And then what did you hear? That it was remodeled. It was changed. So of course, in 2003, when they go and do it, the paint chips don't match. Now when it tells you, oh, well, the paint chips stay the same, you don't know what all the remodeling was in the house because it had changed. So there wouldn't be any paint chips that matched what was in her hair. Next, we talked about the bags that his DNA is not found on. But Mr. Fawcett talked to you about that. If we believe when the last time anyone besides him seen her, we know that in February of 1999, she didn't call her mother for her birthday. We know in March of 1999, she didn't appear for the court hearing for the battery case from July. So we know she's probably deceased, I would suspect, somewhere after Christmas of 98. Probably January or so of 99. So those bags were probably in that area for at least 3 months before they found them. People could be touching the bag, not realizing that it's a head in the bag, not realizing what's in it, they're picking it up, they're putting it away, whatever they're doing, there's other DNA on there. He already told you, because that's what he told Tina, what did she tell Tina, Miss Parent, all of them while they were sitting at the Waffle House, he know how to hide a body. Well, I suspect he know how to use some gloves to hide the body. Suspect he knows how to use some bleach. Remember someone said it looked like there was some liquid in the bags? See, you have to remember all of the evidence that came out. Well, he had the reciprocated saw, so we know he chopped up the body. Where's the torso at? But we're going to get to the torso in a moment. And he discarded it. So that's why there's his DNA wasn't on the bag. Let's talk about the blood, no blood after they moved off. Well, if she was strangled, there would be no blood. And is it reasonable he strangled her? Yes. You want to know why? Because her sister told you that she came in to the Waffle House in early of 1998 with strangulation marks on her neck. That's what she told you. So is it reasonable that he strangled her? Yes. So that's why there wouldn't be any blood. So that's why if they luminol, there wouldn't be anything. What we know, he strangled her. What do we know from Dorothy? He punched her. What do we know from the report? He dragged her. That's the way that he harmed her. There's no evidence that he used guns or knives. All of the evidence shows that he used his physical hands to hurt her. that he strangled her, but it would be nice if we had her neck to really be able to tell you what he did. But see, they don't want to talk about that part of it. Let's talk about the pubic hairs. Well, what do we know? Thomas Dixon told you that they were intimate. What did he also tell you? The last time he saw her was in December of 1998. Could it be that the day that, remember when he said, the last time I saw her, she left with him? So now you're pregnant, probably by Thomas. You're left with him, so now I'm mad because you want to leave me. And I strangle you and kill you. You're right, pubic hair could be Thomas Dixon. So the fact that there's no physical evidence doesn't mean it doesn't point to him, because there's a reasonable reason why there's no physical evidence. No physical evidence. So they showed you the rain shower report. Well, the only month I see here is April. If she was died in January, February, or March, where's the rain report for those months? You have to start thinking about what they want to give you, because they want you to go all over the place and not on the right path. Her body was sitting out there for months. She was severely decomposed. What did the ME say? I can't even tell you. It could be 30 days. It could be longer than that. I submit to you it was longer than that because her mother did not hear from her in February. Let's look at the evidence, y'all. And that is evidence. That's what came out on the stand. Everything that came out on the stand is evidence. Stand in the box. Don't believe any of the state's witnesses about what you did. So everybody lying. Tina doesn't know Dorothy. Remember, because I asked her. Dorothy don't know Tina. But somehow they both saw Melissa with bruises. So they both lying? Why? What would they need to lie for? Matter of fact, Miss Dorothy, if you remember, if you watched her, when she came in here, she looked over at him. I guess she remembered seeing him from back in the day. And she kind of got a soft look on her face. And she tried to switch it up on him. If you can remember, because first I asked her, did you hear her yelling? She's like, I heard both of them yelling. And I said, is that what you told me and my investigator last week? And she's like, well, that's not what I said. And she changed the story. She wanted to help him. See, y'all gotta remember those little things. But then, as she was getting crossed, if you remember, she said at one point, I used to hear her scream. She said, I used to hear her screaming. What did she tell you? That she heard it 3 to 4 times a week. Let's assume that they moved over to Brookline in January, February 1998. You know, we lawyers, I don't do a lot of math. But she's 3 to 4 times a week. So say 4. So I'm good with that. 4 4 is 16. Times that by however many other months. How many times was she hearing this poor baby scream every week? But they want you to believe that no domestic violence was happening? You gotta start thinking about the evidence, y'all. Because they didn't talk to you about that. Thomas Dixon, he don't know Dorothy. He don't know Tina. But somehow Melissa was able to tell him about what happened to her in July, but he come to here and he's lying too. Remember when he told you that I had been in prison for about 10 years and I saw her missing face on some cards. That's how he remembered that that's how he knew she had passed. And wanted to tell everyone about what she told him. And is that unreasonable? Because maybe he was her peace and solace to get away from him. You know, he asked questions about them being on the roof of the Waffle House. Maybe that was the only place she could get some peace, on the roof of the Waffle House. From him. What did, now I know she said all she do is smoke take heroin every day, but what she tell you today? That when she called her friend, the last in 1998, he didn't want her to speak to anybody. So we're supposed to disregard all of that. I submit you don't do that, because that's evidence. Now the rocks. You know, he said, you know, I guess he claims that Ms. Brock told him on the phone that he returned the song. He didn't play that interview for you. He played Wendy's interview. So where's that interview? The interview you heard is when the Brock said he borrowed the song. Matter of fact, they corrected the police. The police said, you know, he stole the song. No, he didn't steal the song. He borrowed the song. And they said on their own, and he never brought it in. And they told you, that's not the reason why we fired him, but he never brought the song back. And remember what we asked them earlier? In the culture of that job, they don't really ask what you use the saw for. They just use, you know, they let their employees borrow the saw. That's evidence, because how ironic is it that her body and the bones have lines from a reciprocating saw that he's so having to borrow from the job that he worked in. And it hasn't been returned. Ladies and gentlemen, this is evidence. And then, you know, this whole thing that he was cooperative, he gave DNA samples, he did this. Well, he did those things because he believed he covered up the murder. He believed that he did what he needed to do to cover up the murder. But when it is time to now be held accountable, what is he doing? And we're going to see the video there in a moment. He first sends his girlfriend out to say he's not home. They skip over that part. When the police get there, she opens up the door, she comes out and says, he's not there. But what did O'Hare say? Because of the cell phone, they knew he was in the house. So he kept looking. And y'all saw the video, he looked, I think he thought he was behind that mirror, he kept on going back to that mirror. And then eventually he's like, no, he's here. And he knocks on that makeshift thing that he done cooked up himself in. But he's cooperative? This is gonna, when I go through all their reasonable theory, the medical exam. What did she tell you? In her expert opinion, she did not die of natural causes. It was undetermined by highly likely homicidal violence. And what did she tell you? If we only had the test. And why would we not get the torso? Could it be because she was pregnant? And he wanted to make sure that we never found that part of her. So you're going to get this instruction from the court, and this is what both Mr. Fawcett and Ms. McDermott discussed. You will be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories. Reasonable. Your duty, when you go back, a reasonable doubt is a doubt of a fair-minded and partial juror honestly seeking the truth. It's not arbitrary, it's not vague. So let's talk about their reasonable theories. So the first one, a random person in the West End decided to kill her child and decapitate her and cut off her legs. What evidence is there? There's no evidence. The only evidence of her walking down the street comes from the defendant. who has all reason to lie. We're going to talk about when he said it. When he says this idea of her walking down the street. That she's hanging out with people who do drugs and alcohol. Who? Who? That's not reasonable. There's no evidence of it. Next is the male, they don't have his name, who molested her as a child. What evidence is it that he came from wherever he may live?
Yeah, so just so y'all know, I've seen some of the comments, right? So the jury has the case, so they're back there deliberating now. I know they typically don't end court until about it usually is around 5:30 their time. So they have about 2 additional hours back there for deliberations. Right now, we're just currently looking at Simone's rebuttal, and then I'll show the jury instructions. But they're back there deliberating, and if that verdict comes in before they leave, then I'll bring that to us. All right.
To come all the way to Atlanta to kill her, to use a saw to cut her, to put her in a bag, to discard her across the street from his job. What evidence? There's no evidence. It has to have some evidence behind it. Not just, oh, you think this in the world, not that it's a possibility. It has to be reasonable. The new boyfriend, Thomas, he told you the last time he saw her was at the Waffle House. You can assess his credibility. There's no indication that he even knew where Avon Avenue is. They sure didn't ask him. They sure didn't cross him on that. Because if you really suspected it was the boyfriend, you would have crossed him on it. The same way they crossed it, Norma, or what her and Carl did, they would have crossed Thomas on that. They didn't. Because they know that's not reasonable. There's no evidence of it. You can't just pull it out of the air. That's not what justice requires. That's not what we ask of you. A drug deal gone bad? Since when is she a drug dealer? Where's that coming from? An overdose? What you heard is that everyone's trying to keep her away from drugs. Remember Wendy said when she was doing meth, she didn't want her to do the meth. What did Tina say? I was doing my thing. I didn't have my sister around me when I was doing my thing. So where's this evidence? They're throwing things to the wall to see if something will stick. Suicide. Well, and we told you that that's not the case. Would you gonna kill yourself? Or why would someone, like, that doesn't make sense. So someone finds you dead and now they feel like they need to discard your body in a way. Why would they just leave you there? If it was a suicide. And then Carl and Norma Patton. You know, when Mr. McDermott said, we're not saying it's Carl and Norma Patton, my mouth dropped. Every cross-examination was about what Norma and Carl did. That they had something happened in their living room. That Norma helped them in the living room. But what they didn't talk about is that Carl and Norma were looking for their baby when they didn't hear from her in February 1999. That they drove from their home in Stockbridge to go look for their child. That even when Mr. Patton got arrested in 2003, the first thing he wanted to do said, you got me? Go find the person who killed my child. That's what he said. Norma said, look, you got me? I'll testify against my husband. Find killed my child. And they want you to believe that those are the two people who killed their daughter for what reason? Oh, now she wanted money. Most kids want money from their parents. I think I still ask my daddy for money every day. That means he's gonna kill me because I asked for money. Most people want to take care of their children, protect their children. You have to make it make sense, and it does. So, we talked about this, but you get to decide who you believe. You know, when you have Miss Patton, Tina, look at their testimony in comparison to Kimberly, his sister, compared to Kathy, his mother. You can assess that. Why is it that Kimberly and Kathy can't remember a thing? Nothing. Nothing. I don't know. I don't know. You don't remember anything? Kimberly, that's your best friend. She was with you when you were driving on the road. And you don't remember anything about what she told you about your brother? But yet, Calhoun can come in here and tell you said that she wanted to leave your brother. She loved your brother. She wanted to leave him. She can't remember that. Why? Is it because remembering that will show that she wanted to leave your brother? And she don't want to be with your brother anymore? Mom can't remember that she never used to talk about Melissa to her grandkids? She can't remember if she went to go look for her or not? Why? But they don't want you to believe Norma and Tina. And Norma came here and told you, this is what I did, this is what happened. She remembered everything that happened. She corrected us at times. But they want you to be so concerned about her past that you're not listening to what she's telling you right here today. I submit you, don't fall down that path. Don't fall down that trail. Your duty is to seek the truth, follow the law, and deliberate. If for some reason you want back and one of your members say, I don't want to deliberate, they will hide in the bathroom, come out and shut the judge. Well, you don't come out, but you should write it and let the court know that one of your members is not deliberating. So let's talk about how we prove that. We don't have to prove motive. However, any evidence of motive is admitted for your use in determining the defendant's state of mind at the time of defense. This isn't a domestic violence case. This is a case of domestic violence. This defendant used his power and control from the time that she was 15. From the time that she was running out the house, from the time she was running away with him, he began to control her. What did Wendy say? She's easily controlled. She's a follower. That she's acceptable. She's going. And he knew that. She's stealing cars for him or with him. She's out here leaving the house, trying to be with him. And the mom said, I didn't like the boy from the time I saw him at 15. Sometimes that's just a mother's intuition. Tension building. Tension building. What did Dorothy tell you? The argument. That's tension building. The breaking of the glass. That's tension building. The incident. The marks on the neck. The incident. The July incident. The incident. The black eye that Dorothy saw. Those are all incidents. And those are what people saw. We know sometimes domestic violence happens in the kinds of things that people will never see. The reconciliation. Her wanting to go back to him. The TPO hearing where she drops the TPO.
Your Honor, we would approach.
Sure.
Domestic violence relationship. And if there was a calm period, she went back. We know that he went to court with her, so those could have been times of that calming period. We talked about the different ways in which we exert power and control. So let's talk about some of the ways of exerting power and control. Isolation. What did we learn? When she got to Brookline, she didn't have any friends. What did Kimberly tell you? I started living my life. So we weren't friends anymore. What did Wendy tell you? They weren't friends anymore. What did her sister tell you? That, we started hanging out again more and more once she started working at the Waffle House. So her connections weren't there. Her connections were down in Stockbridge. She was naive, easily influenced, believed what anyone tells her. We talked about the physical violence, using her children. I submit what happened in that room when the judge allowed them to talk is that he convinced her, his mom and kids. And she did. You give permanent custody to permanent guardianship to my mother. And that is a form of control. Now your mother, the abuser's mother, now has her children, can dictate what the children do. We know that they didn't tell them about their mother. What did Ms. James tell us about the role of a perpetrator? Plays the hero, the judge, and the victim. He's a hero when he's saving her from the house. A hero when he's taking her from the home, when she's running over to his support. He judges her when she wants to go back and be with her family, spend time with her family. Not allow her to talk to her family. And then when she finally decides that she's tired and enough is enough, as she told Kimberly that I was done, he plays the victim. You can't leave me. Look what I've done for you. Look at how we are in my grandmother's home together. Look at how I saved you from your family, saved you from your trauma, saved you. You can't leave me. Abusive, we already talked about it. He was controlling. Melissa, fragile-minded, a follower, easy to control, weak, not the type to fight, naive, dependent. Again, evidence of his controlling behavior. Motive, pregnant by another man. Because remember Thomas Dixon said it, thought it was his. And leaving him for another man. And what did Rosa tell us? The most violent time for a victim of domestic violence is when she wants to leave. Is when she wants to leave. And she was leaving him. She found solace in Mr. Dixon. And he was going to lose control of her. That is why he killed her. She was going to leave him. She was leaving him. Now let's go through a timeline very quickly. Late 1997, early 1998. She goes to Waffle House crying with a bruise on her neck. Melissa indicates to her sister that Chris caused the mark on her neck. She initially tries to confront Christopher. Melissa doesn't want her to confront him. Troy instead hits Chris. Tina drops Melissa home and confronts Chris about hitting his sister. Those are two separate times. And then we know about the time at the Waffle House where he makes an ugly comment. He knows how to hide a dead body. January to March of 1998, Melissa and Christopher moved to the grandparents' house on Brookline, again away from her family and friends. She's working at the Waffle House in New York. Remember? So Melissa, March of 1998, Melissa visits her sister at Waffle House on Virginia Avenue and surprised her for her birthday. Remember when Tina testified, she said, I thought it was 99, but my mom did correct me and I realized it was 1998 and she remembered the wrestling people coming in and that's how she was able to remember the date. So it was 1998. And we know it's not 1999 because if you believe what her mother tells us, she did not call for the birthday and she did not appear for the court hearing in March. It's reasonable to believe she was deceased by then. Again, Melissa's still working at Waffle House in Doraville, and Christopher's not working at Action last year. He didn't start until October. January through July, we talked about this. Dorothy hears arguing, sees Melissa with glass on her face and blue under her eye. She saw Melissa with a baby maybe once or twice. You know about the July 21st APD police report. Melissa applies for a protective order. She seeks petition to terminate guardianship on the 23rd. Temporary protective order hearing. Chris is allowed to speak with Melissa privately. That's when, after that meeting, is when Melissa asked for the TPO to be dropped. On the same day, she asked her mother to pick up the children from daycare and take them to Kathy Wolfenbarger and give permanent guardianship to Kathy Wolfenbarger. October 1998, Chris begins working at Action Glass. Melissa's probation court hearing. She tells the judge that she's pregnant. November 9, 1998, Norma sees Melissa at a court hearing. She leaves the court hearing with Chris. This is the last time that Norma sees her daughter. Thanksgiving 1998, Wendy Waddell calls Melissa. Chris does not allow her to use the phone. He's controlling Melissa's ability to speak to her friends. Melissa does not call her family on Thanksgiving. December 98, we know that Thomas sees Melissa at the Waffle House. He says to Chris, because he comes in, Melissa's crying, you can have her after 9 o'clock p.m. Chris waits outside. Melissa leaves with Chris. He never sees her again. According to the Wolfenbarger family, they see her at a family function in December of 1998. Again, her family does not hear from her. February 1999, she doesn't call her mother for her birthday. Carl Patton goes to Tina's job to inquire about Melissa's whereabouts. Christopher is fired from the job, but he had borrowed a reciprocating saw and had not returned. March 1999, Melissa is not present and cannot be located for the battery trial. April 1999, her head recovered is unidentified. Other extremities recovered, unidentified. February 99 and January 2000, we know that Ms. Norma Patton is seeking assistance to locate Melissa, reaches out to several law enforcement agencies and receives no assistance. She speaks to a lawyer who puts her in touch with the Henry County Police Department. January, files the Melissa police report, Detective Scott assigned to the case. January 2000, Detective Scott does initial interviews with various family members to include or attempt to include Melissa's husband, the defendant. This is in January 2000. About 9 months later, he speaks to Catherine Wolfenbarger, and she is reluctant to speak to police or give police any contact information for Chris. 2001, he finally speaks to Chris, so it's 2.5 years after the remains are found, 18 months after the missing persons report, and 18 months before the remains are identified. And here's what he says. First, about her personality. And these are his words.
Yeah, we're talking about, you got to understand, I don't know what all they told you about the mentality of her. She's not real, she didn't have a whole lot of street smarts at all. She was real smart, though. She had a lot of book smarts. She was real intelligent that way. But as far as, she was real naive. And I'm a little that way, but not quite like that. She would basically, if you could put an idea in her head and get her to thinking about it, she would swear that's right. And I guess that's why she had so much problem, running away and all the time. But she was a real follower.
He said, you put an idea in her head, she will follow. She's a follower. That's What did he say about her when she stayed with him? These are his words.
So she stayed with you for about a week, and then.
She stayed with me for a few days and stuff like that. Sporadically, yeah. I'll say almost a month. I would say 3 weeks. Cause it was right around, it was almost Christmas, I remember.
So what does he say? She was sporadically with her until about December of 1998. No other person besides Chris sees her after December of 1990. What's he say? Because this idea that it's Norma who did this in 2001, he says this about her mother.
But there's no way I believe that she ain't called her mom. That's the whole reason I ain't even, heard it.
He said, there's no reason why she wouldn't call her mom. I haven't been over there yet. In 2001, he figured she would be calling her mom. That's what he's telling the police. So why all of a sudden now it's her mom could have killed her? And it corroborates what Norma said. She was concerned at Christmas when she didn't see Melissa, and she's even more concerned when she didn't hear from her on her birthday. So this is what you have to listen to. That he saw her in April of 1999.
After she left, I didn't hear too much from her for, a couple months. I was like, whatever. But back in April the following year, which I guess would be 99, I seen her. And man, I was coming down Lee Street. I don't know if you know about the line like that, but it's right there, right where the train station is in the west end. I was coming down through there, and she was walking the road, and me just being a white girl, I was blowing a horn because we're a dying breed around there, But I stopped and I blew the horn at her, and I got down the road down by Krispy Kreme, turned around and come back. I'm like, I got thinking who it was, and I couldn't believe it, man. She just, I don't know, I guess her sister could tell you how she looked. You got to picture how she looked when she was right there. I got this on when that was done. Yeah, see, that was before. That was like she looked like right after we got married. After that, man, she cut all her hair short, dyed it red, started smoking. She looked totally different than that. But when I see her come back, man, she was real bad. She went off the gate and everything. I was like, man, I couldn't believe it. It broke my heart. But we stopped and she said she wanted to talk, so we went. I went up to Taco Bell. We ordered a little deal, whatever, And at that time, she was like, I made a mistake. I want to come back home. And I was like, man, you don't know the emotional stuff, whatever it's going through for me, just like this.
So what? He said, I know it's my fault. When we finish this, you got to ask the county commissioners to do the assistance. But what he says is he saw her in April of 99 when he was driving down Lee Street in the West. And that she had bright red hair and that she had track marks on her arm. Ladies and gentlemen, in April of 1999, her head was severely decomposed on April 29th. How is it that he saw her walking down the street and able to describe that she had short red hair? What did his mother and his sister say? The last time we saw her in December, her hair was down to here. But he sees her in April walking down the street. But she didn't call her mom. She hasn't called any of her family members, but yet he saw her and describes vividly. This is in 2001. This is before her body's identified. This is before anyone knows that the remains are hers. This is when he thought that no one would be able to find her. This is what he's telling the police in the missing persons report. And you have to remember that he abruptly leaves the neighborhood in early 1999. Why? That is your mother's home, your grandmother's home. Why would you need to leave that house abruptly? There's no reason except you had to get out that neighborhood. Let's see if this one works. But he tells them later on in that same interview again that he saw her in April of 1999.
I mean, she had dyed her hair several months before, but then right there towards the end, and especially when I see her in April, her hair was real short, real bright. It was like, you know, they look odd. It definitely stood out. I mean, she didn't look nothing like that.
So he said she had dyed her hair a few months before. No one else has seen this except for him. He also says, and I'll try to play, but if it doesn't work, we'll keep moving, that she must have changed her name. Why would Melissa need to change her name? There would be no reason for her to change her name. Why? Again, this is in 2001. He wants people to think that she's moved away and just changed her name. She already wanted to leave him. She didn't want to be with him. She already started a relationship with someone else. So what reason would she need to change her name?
I know that she would like to say, based on what I think of, all right, now I really don't know, but it's just my opinion. And she went through, because to this day, she's still married to me. I'm not, you know, just now, you know, I guess going through divorce, whatever, I'm trying to do all that. But
It's not, and I'll say this as a reminder, if there are any videos that you would want to hear, you can do that if you're what you're doing for it. He also tells them in this same interview, you have to cut everyone off. Again, why would she need to do that? She had her family who loved her, her family who cared about her, her mother, her father who picked her up after the July 21st incident. There would be no need for her to cut anyone off. But again, he was trying to cover it up because again, this is before anyone knows who she is.
I mean, she had dyed her hair several months.
In 2002, he files for and is granted a divorce from Melissa. He also says in that 2001 interview that he's been working on the divorce since 2001. If you thought she just went away, you didn't think she was going to come back at all? Why are you filing for the divorce? You're filing because you know she's never coming back. March 18, 2003, Detective Scott and Calhoun meet with Chris. This is a few days after the remains are identified. If you remember, they kind of confirmed his story before telling him that she's been identified. And again, in this interview, he says the same thing. He saw her in March and April of 1999. Now he says he dropped her off at the train station and that was it. She just disappeared in the night. With no one else to see her, that story is a lie. And again, he's the last person to say he saw her.
Say the year she disappeared. I've been sitting here, I don't know if it's 98, 99. I know 2000, I was looking for that, so it can't be 2000. But whatever year that they're saying that they seen her, I know I seen her like in early March or April of the next year. And that was the last time I'd seen her. That's November of 98 is when they're saying. That's Thanksgiving. All right. And then so end of the next year, 99, early 99, March, April, somewhere near when you think you ran into her. And he's probably more familiar with the area than I am, but said that was Hornet. She was walking from like the Martin train station up from Brookline. Is that right? Yeah. Right there on Lee Street. Y'all went to a Taco Bell in the area there and talked a little bit. And what happened? She walked off, rode away, and I dropped her off at the train station. Yeah, so you would drive. What kind of vehicle you had? I had I want to say it's a tan colored Chevy Caprice, like a brown color. I mean, I can't be certain on that because I've had got off of mini cars
Then he says, you know, he looked better than the last time he saw her. In 2001, she looked like she was doing something. He kept on saying track marks, but now in 2003, she looked better than the last time she saw her. They don't run out of time, so I'm going to speed through this pretty quick.
What's the last?
This idea that she may have gotten drug overdose, what he says is she was not on drugs while they were together. So this idea, he said.
When people do stuff like that, kind of just disappear from the family and just run, you know, haphazard lifestyle like that, they're already on drugs. That's what I'm trying to say.
Oh yeah, she wasn't on nothing when we were together. You know, I'll say we smoke reefer every now and then, you know, just fun where we go to concerts or something, do go out or something. You know, might drink regular alcohol or something.
She went on drugs. So all of a sudden, the defense is, oh, well, she may have had a drug overdose. He says it. And it's in 2003. He talks about the divorce being final. We don't need to play that clip. She wasn't afraid of her dad or anyone getting revenge.
Was she ever afraid either of him or somebody that, you know, might be trying to get revenge?
No, I don't know if she did. She never let on nothing like that.
She never acted that way.
No, she was always more quiet or didn't.
So now all of a sudden somebody wants to get revenge on her? That's not what he said. She loved her.
I was just getting at how much you knew. Was she was ever afraid of him? You know,
She was afraid of her mom, but she couldn't stand her mom. I'm not really sure that's what, you know, that's what's got me starting now or whatever, because, I mean, it always seemed to me like, you know, she loved her dad, you know, with her dad, but her mom was always, every time she run away, whatever, you know, she would come and tell me she was running away from her mom. I mean, I don't know, that's why I couldn't really say, I don't know, I just couldn't see him doing anything to her. I don't know, that's why I guess that's why I can't really think she'd be dead. You know, or it could be a homicide or whatever.
You can't see her. This is her dad doing anything. Now in May, you've heard this interview, so I won't play it. There's clips in here, but I'll highlight a few things for you. But this is the May 5th, 2021. This is now 18 years after the head and extremists have been identified, 6 years after media attention has been brought to the case. He talks about the last time he saw her. Now he doesn't really remember. And you know, we understand that memory fades. But the defendant nor his family can remember a thing about this woman who's the mother of his child. And you heard it. You heard the interview already.
in view.
He thought she just left and moved on. Well, when she didn't come back, you didn't call the authorities. You didn't report her to anyone. This is the mother of your children. This is your wife. And you don't say anything? He never wanted to reach out to assist her own family, became worried. He didn't even want to speak to the police. Back in 2001. It took him 18 months to do this. Why?
When she was leaving,
Now, all of a sudden, her parents killed her. In 2003, there's no way her dad could do it. But now that the media's been on it, now that it's been highlighted, now that the road is leading to him, he says her parents did. And that's convenient. Let's blame the individual who was accused of accused of killing multiple people, and let's blame him.
What do you think happened to Melissa?
2023, the police meet with Chris Wolfenbarger, and investigation continues. And then here he is, hiding behind the wine rack in here. And he's hiding just like he told his daughter. When I have to go on the run, because that's what he told him, when I have to do it, I know where to go. You saw Christina here. She had no reason to make that up. And that's exactly what he did. Had a makeshift place to go hide. Now they said that we want you to do a legal logic. No, we don't. We want you to follow the path. Physical abuse at 98. Mom sees her last time in November of 98. She wants to leave him. He borrows a reciprocated assault, never returns it. She does not call her mother for the holidays. He does not appear for the March battery. She doesn't appear for the March battery trial. Carl Patton goes looking for his daughter. He abruptly leaves the neighborhood without telling anyone, leaving all of his clothes. Her head is found on April 29th, across from his job, severely decomposed. Extremities found in June, across from his job. He's the only person familiar with that neighborhood. His mom doesn't know where to go. What did Miss Patton say? The only time we went up there is when we went to go pick her up. They're not familiar with Atlanta. He is. Cut marks on her bones appear to be done by reciprocated assault, consistent with the type that he took from the job. Her torso never recovered. Could it be because she was pregnant? He never reports his wife missing. Reported missing by her mom in January. Mom's reluctant to give information. He lies to police in September. Never speaks to his children about their mother. Body parts found in ATL. No other family resides here. This is where everything is found. From the house to his job to the location of the home. This is not a legal logic. We're not asking you to jump. We're asking you to follow the path. And all the evidence leads to one conclusion. He's guilty. Now, ladies and gentlemen, we might not have all the puzzles. We wish we had her torso. He was clever enough not to leave DNA. But what we do have is this. You can still see this dollar bill, even with all of the missing pieces. You still see that the path leads to only one person, only one conclusion. Now, sometimes things are challenging, and this is going to be hard for you all to see. But this young lady right here should not have been left like that. This young lady deserves to have raised her children. This young lady deserved to have lived a life. This lady deserved to have continued to work, to be a part of her children's lives, her grandchildren's lives, but she is not. The defense has operated on what if this, what if these possibilities, what if. We want you to focus on what evidence came out of the trial, what the reasonable conclusion is, and you will not be telling him something that isn't already known. For 27 years, he's known what he has done. For 27 years, he has sat and hid from justice. We are imploring you, we are asking you. Don't listen to these fabricated stories for what the defense is telling you. When you follow the truth, when you seek the truth, there is only one true result. That this defendant, Mr. Wolfenbarger, is guilty of murder. And we're going to ask that you do that. Evil prevailed when the men and women fail to act. I'm asking you to act. We are asking you to act. And we are asking you to find him guilty. Thank you.
Thank you. Ladies and gentlemen, I'm going to, in a moment, just give you the charge of the court, which is that law that I promised when I first swore you in to be jurors in this case. And I, too, have a PowerPoint. And mostly I do that so that people process things differently. And so some people hear things better and understand it by hearing it. Some people, it's helpful for them to see it. You will have a copy of these jury instructions with you in the jury room while you deliberate. Ladies and gentlemen, you are considering the case of the state of Georgia versus Christopher Wolfenbarger.
Now, the lawyers have referred to some of the governing rules of law in their arguments, and if there is any difference in the law that was stated by the lawyers and as stated in these instructions, you are governed by these instructions. Nothing I say in these instructions indicates that I have any opinion about the facts. You, not I, have the duty to determine the facts. You must perform your duty as jurors without bias or prejudice to any party. The law does not permit you to be controlled by sympathy, prejudice, or public opinion. All parties expect that you will carefully and impartially consider all the evidence, follow the law as it is now being given to you, and reach a just verdict, regardless of the consequences. Excuse me. You have been selected and sworn to try the criminal case of the state of Georgia versus Christopher Wolfenbarger. The Fulton County Grand Jury has indicted Christopher Wolfenbarger for murder. I will now read you that indictment. In the state of Georgia, in the county of Fulton, in the Superior Court of said county, the grand jurors selected, chosen, and sworn for the county of Fulton, in the name and behalf of the citizens of Georgia, do charge and accuse Christopher Wolfenbarger with the offense of murder. For the said accused in the county of Fulton in the state of Georgia, sometime between the 10th day of December 1998 and the 29th day of April 1999,
exact date being unknown to the grand jurors at this time, did unlawfully and with malice aforethought caused the death of Melissa Dawn Wolfenbarger, a human being, by inflicting homicidal violence upon her in a manner unknown to the grand jurors at this time, contrary to the laws of said state, the good order,
peace, and dignity thereof. Ladies and gentlemen, you will have the indictment with you in the jury room, along with a copy of these instructions and a verdict form. The defendant has pleaded not guilty to this indictment, and he denies every charge in it. This indictment and the defendant's plea of not guilty present the issue that you have been selected and sworn to decide. The indictment is the way the defendant is charged with committing crimes that violate the laws of Georgia. The charge in the indictment and the plea of not guilty are not evidence of guilt, and you may not conclude that the defendant is guilty based on the charge or the not guilty plea. The defendant is presumed to be innocent until he is proven guilty. The defendant begins the trial with a presumption of innocence in his favor, and this presumption stays with him until it is overcome by the state with evidence that convinces you beyond a reasonable doubt that the defendant is guilty of the crime charged. You may not convict the defendant of any crime unless each element of the crime is proved beyond a reasonable doubt. The burden of proof is on the state to prove every essential element of the crimes charged in the indictment beyond a reasonable doubt. The defendant has no burden of proof at all, and the burden never shifts to the defendant to prove his innocence. When a defense is raised by the evidence, the burden is on the state to negate or disprove it beyond a reasonable doubt. However, the state is not required to prove the guilt of the defendant beyond all doubt or to a mathematical certainty. A reasonable doubt means just what it says. It is the doubt of a fair-minded, impartial juror who is honestly seeking the truth. It is a doubt based on common sense and reason. It does not mean a vague or arbitrary doubt, but it is a doubt for which you can give a reason based on the consideration of the evidence or lack of evidence, a conflict in the evidence, or any combination of these. After considering all of the facts and circumstances of this case, if your minds are wavering, unsettled, or unsatisfied, then that is a doubt of the law, and you must find the defendant not guilty. But if no reasonable doubt exists in your minds about the defendant's guilt, then you may convict the defendant. If the state does not prove the defendant's guilt beyond a reasonable doubt, your duty would be to find the defendant not guilty. Facts and circumstances that merely place upon the defendant a grave suspicion of the crime charged, or that merely raise a speculation or conjecture of the defendant's guilt, are not sufficient to authorize a conviction of the defendant. Members of the jury, it is my duty and responsibility to determine the law that applies to this case and to instruct you on that law. You are bound by these instructions. It is your responsibility to determine the facts of the case from all of the evidence presented, and then you must apply the law that I give you in the charge to the facts as you find them to be. Your oath requires that you will decide this case based on the evidence. Evidence is how a fact is proved or disproved. Evidence can be either testimony or exhibits. Testimony is what you hear from people who take the witness stand and swear to tell the truth. However, the questions the lawyers ask the witnesses are not evidence. Exhibits are documents, photographs, or other physical items that are admitted during trial. Evidence does not include the indictment, the plea of not guilty, opening or closing remarks of the attorneys, or the questions asked by the attorneys. Evidence may be either direct or circumstantial or both.
Considering the evidence, you may use reasoning and common sense to make deductions and reach conclusions. You should not be concerned about whether the evidence is direct or circumstantial. Direct evidence is the testimony of a person who asserts that he or she has actual knowledge of a fact, such as by personally observing or otherwise witnessing that fact. Circumstantial evidence is proof of a set of facts or circumstances that tend to prove or disprove another fact by inference, that is, by consistency with such fact or elimination of other facts. There is no legal difference in the weight that you may give to
either direct or circumstantial evidence. You would be authorized to convict only if the evidence, whether direct, circumstantial, or both, excludes all reasonable theories of innocence and proves the guilt of the accused beyond a reasonable doubt. The jury must determine the credibility of the witnesses. In deciding this, you may consider all the facts and circumstances of the case, including the witness's manner of testifying, their means and opportunity of knowing the facts about which they testify, the nature of the facts about which they testify, the probability or improbability of their testimony, their interest or lack of interest in the outcome of the case, and their personal credibility as you observe it. Testimony has been given in this case by certain witnesses who are termed experts. Expert witnesses are those who, because of their training and experience, possess knowledge in a particular field that is not common knowledge or known to the average citizen. The law permits expert witnesses to give their opinions based upon that training and experience. You are not required to accept the testimony of any witnesses, expert or otherwise. Testimony of an expert, like that of all witnesses, is to be given only such weight and credit as you think it is properly entitled to receive. To impeach a witness is to show that the witness is unworthy of belief. A witness may be impeached by disproving the facts to which the witness testified. In determining the credibility of a witness, you may consider evidence offered to attack, challenge, or cast doubt on the witness's credibility. This may include evidence of criminal convictions as shown by proof that the witness has been convicted of the offense of a felony or a crime of dishonesty. Your assessment of a witness's credibility may be affected by comparing or contrasting that testimony to statements or testimony of that same witness before the trial started. It is for you to decide whether there is a reasonable explanation for any inconsistency in a witness's pretrial statements and testimony when compared to the same witness's trial testimony. As with all issues of witness credibility, you, the jury, must apply your common sense and reason to decide what testimony you believe or do not believe. The testimony of a single witness, if believed, is sufficient to establish a fact. Generally, there is no legal requirement of corroboration of a witness, provided you find the evidence to be sufficient. A defendant in a criminal case may take the stand and testify and be examined and cross-examined as any other witness. You should evaluate such testimony as you would that of any other witness. However, a defendant does not have to present any evidence or testify. And when a defendant chooses not to testify, you may not consider that in any way in making your decision. You have received evidence of prior convictions of witnesses who testified in this case. You may consider this evidence only insofar as it may relate to attacking the credibility of the witness and not for any other purpose. It is for you to say whether under the evidence in this case, the testimony of the witnesses and the facts and circumstances of the case sufficiently identify a defendant beyond a reasonable doubt as the perpetrator of the alleged crime. It is not necessary that a defendant show that another person committed the alleged offense. If you do not believe that a defendant has been sufficiently identified as the person who committed the alleged crime, or if you have any reasonable doubt about such, then it would be your duty to acquit the defendant. The burden of proof rests upon the state to prove beyond a reasonable doubt the identity of a defendant as the person who committed the crime alleged in this bill of indictment. Defendant is charged with a crime against the laws of this state. A crime is a violation of a statute of this state in which there is a joint operation of an act or omission to act and intention. Intent is an essential element of any crime and must be proved by the state beyond a reasonable doubt. Intent may be shown in many ways, provided you, the jury, believe that it existed from the proven facts before you. It may be inferred from the proven circumstances or by acts and conduct, or it may be, in your discretion, inferred when it is the natural and necessary consequence of the act. Whether or not you draw such an inference is a matter solely within your discretion. A defendant will not be presumed to have acted with criminal intent, but you may find such intention or the absence of it upon a consideration of words, conduct, demeanor, motive, and other circumstances connected with the act for which the accused is being prosecuted. Every person is presumed to be of sound mind and discretion, but this presumption may be rebutted. You may infer, if you wish to do so, that the acts of a person of sound mind and discretion are the product of that person's will, and a person of sound mind and discretion intends the natural and probable consequences of those acts. Whether or not you make any such inference or inferences is a matter solely within the discretion of the jury. A person commits malice murder when that person causes the death of another person unlawfully and with malice aforethought. The killing must have been done with malice to be murder. Malice, as the term is used here, is not necessarily ill will or hatred. Rather, it is the unlawful intent to kill without justification, excuse, or mitigation. You may find malice when the circumstances show that the defendant acted with the deliberate intention to unlawfully take the life of another person. You may also find malice when there does not appear to be significant provocation and all the circumstances of the killing show an abandoned and malignant heart. The state does not have to prove premeditation to prove murder. If a killing is done with malice, it is murder, regardless of how briefly the malicious intent existed. No specific length of time is required for malice to arise in the defendant's mind. Malice may be formed in a moment, and instantly a fatal wound may be inflicted. If malice was in the defendant's mind at the time of the act or the killing and moved the defendant to do it, that is enough for the killing to be murder. The state does not have to prove motive to prove murder. Any evidence of motive has been admitted for your use in determining the defendant's state of mind at the time of the killing. The law provides that criminal actions shall be tried in the county in which the crime was committed. Venue, that is, the crime was committed in Fulton County, is a jurisdictional fact that must be proved by the state beyond a reasonable doubt, as to each crime charged in the indictment, just as any element of the offenses. Venue must be proved by direct or circumstantial evidence, or both. If, after considering the testimony and evidence presented to you, together with the charge of the court, you should find and believe beyond a reasonable doubt that the defendant in Fulton County, Georgia, did commit the offense as alleged in the indictment, you would be authorized to find the defendant guilty. In that event, the form of your verdict would be, we, the jury, find the defendant guilty. If you do not believe that the defendant is guilty of the offense, or if you have any reasonable doubt as to the defendant's guilt, then it would be your duty to acquit the defendant, in which event the form of your verdict would be, we, the jury, find the defendant not guilty. By no rule or comment that the court has made during the progress of this trial has the court intended to express any opinion upon the facts of the case, upon the credibility of the witnesses, upon the evidence, or upon the guilt or innocence of any defendant. Your verdict should be a true verdict based upon your opinion of the evidence according to the laws given you in this charge. It is your duty to consider the facts objectively without favor, affection, or sympathy to either party. In deciding this case, you should not be influenced by sympathy or prejudice because of race, creed, color, religion, national origin, sexual orientation, local or remote residence, or economic status for or against either party. You are only concerned with the guilt or innocence of this defendant. You are not to concern yourselves with punishment. One of your first duties in the jury room will be to choose one of you to be the foreperson. The foreperson will manage your deliberations and will sign the verdict to which all 12 of you freely and voluntarily agree. You should start your deliberations with an open mind, talk with each other, and consider each other's views. Each of you must decide this case for yourself, but you should do so only after discussing and considering the case with fellow jurors. Don't hesitate to change an opinion if you are convinced that it is wrong. However, you should never give up an honest opinion to be congenial or to reach a verdict solely because of the opinions of the other jurors. During your deliberations, you must not communicate with anyone other than your fellow jurors about this case. You are not permitted to conduct any research about this case, including persons, places, or legal concepts mentioned during the trial. These rules apply not only to in-person communication, but also to communication or research using cell phones, text messages, websites, blogs, or social media of any kind. Whatever your verdict is, it must be unanimous, that is, agreed by all. The verdict must be signed in ink by one of your members as foreperson, dated, and returned to be published in open court. The alternate jurors are jurors 43 and 45. You will be given separate instructions by the deputy. You may now retire to the jury room, but do not begin your deliberations until you receive the indictment and any evidence which has been admitted in this case. If you have any questions during your deliberations, please write them out and give them to the deputy. If you wish to take a break during your deliberations, please notify the deputy. But please understand that you may deliberate only when all of you are together as a group in the jury room. Deputy, please escort the jury to the jury room. And ladies and gentlemen, your lunch is there and ready for you.
So the jury is deliberating, right? So we are waiting for a verdict. I can tell you now that they have been deliberating since after lunch, and it is currently 4:35. So I'm thinking that they have probably maybe another hour to deliberate. So we'll stay right here just in case a verdict does come back. Let me see. Are they going to say anything else? Let me see.
Or are we preserved, or you want me to reiterate what they are? It was the.
As far as I'm concerned, they are preserved, Mr. Samuel. The objections that you have already asserted, you had preserved them when I said this is the charge I intend to give. You indicated that you continue to object, and I've of course now given them, so you can object again.
You want me to object again? Okay, the 404B instructions we requested.
Yes, sir.
There were 2 or 3 of those. And the prior difficulties instruction, we think both of which were necessary in this case.
Okay. I do, forgive me for interrupting, I do want to make a note. There was an objection during the closing argument, the second part of the state's closing argument, as to Ms. Hilton. The parties approached. I notified the parties that I would make a note of it and make a record of that objection. The objection was to I think it was a statement by the state regarding actions by Melissa Wolfenbarger in stealing cars, and that somehow that was with or for Christopher Wolfenbarger, I think was what I understood. The discussion that was had at the bench was, number one, that's 404B evidence that was never, that was not appropriate and would not have been admissible, but also I had not heard any evidence about Mr. Wolfenbarger's connection to those alleged car thefts by Ms. Wolfenbarger until that moment. In any event, the objection was preserved, and the party stepped back and the state agreed to move on from that issue rather than highlighting it by withdrawing it. Anything else you want to put on the record regarding that issue, Mr. McDermott?
No, Your Honor.
Ms. Hilton?
No, Your Honor.
Anything else from the defense, Mr. Samuel? I interrupted you, sorry.
You didn't interrupt me.
Okay.
Thank you.
Okay, so can y'all please make sure that y'all have all the evidence together, and that to get it ready to go back to the jury? Deputy, my understanding is that the alternates, Judge Williams has graciously agreed to loan us her jury room for the alternates.
Yes.
So you can once they get their lunch, you can, and it's time for these jurors to deliberate, then we can take them over there. Okay. If y'all can check and get the exhibits together.
Okay, so technically they started deliberating about 2:35. So let's see how long they've been back there. 2:35. They've been back there just now, about 2 hours. So for those of you that did not catch it, the judge did grant a direct verdict in count number 2, which is the felony murder. The reason why is because the judge didn't feel that there was some sufficient evidence that was presented in order to send back to the jury, in order for the jury to consider according to the law. So that count was not sent back with the jury. Will we have a verdict today? I don't know. But we'll stay right here until court closes, and we'll rewatch some more testimony. Yeah, we got about an hour. That's right, film. Yep, about an hour. Maybe they went to lunch before they started deliberating. I'm not sure, but we are still in verdict watch. Let's go here and watch. Well, that's the closing statements. We really don't want to see that. I am going to fast forward. Let me wait. Yeah, so they've been back there about 2 hours. Well, not bad timer. Let's see. Do I see some movement in the court? Let's see. No movement just yet. I'll keep that one up and let me find, we can go back and listen to some testimony. That's always awesome to do. I think the most funniest person that I've seen come up is the one that we had today, the one that they had to drag in there, right? They had to go get her. She had to come in with handcuffs because she did not want to come into court. And quiet as kept, I'm not even sure what she added to this case besides, let me get it up here.
Melissa and throw it where it could be found.
Nope, that's
right
not it.
where Chris.
I notified the parties that I would make a note of it and place make a record of that objection.
Yeah, she was a hoot. They definitely should have probably gave her a hit or two before she got up on the stand, because she looked like she didn't want to be there and like she got better things to do than this stuff here. They definitely didn't prep her good, huh? So let's listen to her testimony again.
Mr. McDermott, the defense may call its next witness.
The defense calls Wendy Waddell.
Okay. Ladies and gentlemen, as you can see, Ms. Waddell is already on the witness stand. Ms. Waddell, if you can, please raise your right hand to the best of your ability. The deputy will swear you in.
You swear affirm to the testimony that you're about to give the truth, the whole truth, and nothing but the truth self.
I do.
Please state and spell your full name for the court, please.
Wendy, W-E-N-D-Y.
And if you could do me a favor and scoot up a little bit so I can hear you in the microphone.
And Waddell, W-A-D-D-E-L-L.
Thank you very much. Go ahead, Mr. McDermott.
Ms. Waddell, suffice it to say you don't want to be here. You need to answer audibly.
You're right.
Did you know Melissa Wolfenbarger?
I did.
And do you know the Patton family?
I do.
Carl and Norma? And how did you know them?
My parents grew up with them.
And did you live next door to them at one point?
As a child,
And were you at one point friends with Melissa?
I was.
Did you go over to her house frequently?
Every weekend. Every weekend.
Thank you. Do you remember something about their house that made you not want to go over there?
Yeah.
And what was that?
It smelled.
Why did it smell?
Well, people just have a smell.
What was the smell like?
Like a person that
Like
stinks.
body odor?
I mean, it wasn't nasty. She wasn't a nasty person.
Was it an offensive smell?
Any smell's an offensive smell.
Did you remember telling?
Are you asking if she was a nasty person? She was not a nasty person.
I'm not asking if she was a nasty person.
Okay.
I'm just asking about facts. You remember speaking with me on the phone a couple of weeks ago?
Yeah.
And you remember telling me that the smell pervaded the house
I
and the
did.
car,
I got it on the car.
and
Got
it
it on the
stuck
house.
on everyone in the house.
It did.
Including Melissa. And you remember telling me that people bullied her for it,
They did.
picked on her? You remember telling me that Melissa had some kind of, it's not a leading question, Your Honor, unless it suggests an answer.
I'm going to overrule and allow it. Go ahead.
Do you remember telling me that Melissa had some sort of skin condition that caused her to have marks on,
Intigo.
and it caused her to have visible marks on her body all the time?
Yep.
And how did you describe those marks? What did they look like?
Scratches.
Did you say bug bites, sores? Thank you. Can you remember how you described Melissa's personality to me?
Well, if I'd look back at it, I'd say autistic.
I'm sorry.
I said, if I had to look back, I would say autistic. She
Okay,
would be autistic.
but you're not a doctor, right?
I'm not.
So you can't diagnose her with autism.
No,
But what made you arrive at the conclusion that she may have been autistic?
just the way she is.
Let me describe those facts.
You know what an autistic person is. I mean,
Was
there's
she quiet?
sure.
Was she shy?
Yes,
Was she reserved?
she was.
Did she sometimes react?
She whined. She cried.
She whined and cried even when she was older. So are you suggesting she may have been a little bit
Of a baby.
infantile for her age?
Yeah.
You described to me a period of time in which you would visit her. Do you remember describing a time to me in which you would visit her almost every day
Every weekend. Yeah.
and that you would be locked in the room with her?
Yeah. Growing up.
And did you tell me that the door locks would be reversed
It
on
would
her
be.
door so that the lock was on the outside?
It was.
And do you remember that she was telling me that she was locked like that every day, all day?
Objection leading. He's giving the answers.
Overruled. Go ahead.
Do you remember telling me that she was locked that way every day, all day? I need an audible answer. I'm sorry.
Yes.
Thank you.
So was her sister. Her sister's right there.
And from what ages do you remember her being locked in the room?
I don't know, 12, 13.
Did you remember telling me it was started at about age 7?
I'm sure it started early.
Went
yeah.
up to about 12?
Yeah.
Okay. You said her sister was locked too?
He's right there.
And she was locked up too?
Mm-hmm.
And
I'm sorry, was that a yes?
Yeah, my mom used to sneak out with her and get her out of the window.
Thank you.
what's your mom's name?
Terry.
Terry Archer, is that correct? And
Is that a yes?
Yes,
Okay,
it is,
guys,
Terry
so
Archer.
I'm
Thank
gonna pause this real quick because it
And,
looks like the
what was your
judge
father's
has
name?
taken the bench
Bobby.
and she is bringing the jury out. So I'm gonna put us
And
back
you
in
said
the
that
courtroom.
your
I will
parents
pause it
were
right
wealthy?
here. I'm not sure if they're coming
Yeah.
out for a question
And
or if
that
they're gonna be
they
ending for the
paid
day, or even if they have a verdict.
Involved in
But
several
let's see.
activities with.
Want to remind you all that I understand that a verdict can be a very emotional, people can have very emotional reactions to verdicts, right? Because we have people here in support of the defendant, we have people here in support of the victim. So I just want to remind you that when I read the verdict, I implore you to please maintain calm, not to shout out. And if you don't feel like you're going to be able to contain your emotions, if you could please step out of the courtroom until you are able to contain your emotions and step back into the courtroom. So with that, as soon as I have my robe, we will get started.
Okay, guys, it looks like we do have a verdict. Okay, guys, I am dropping the link for the case out of Georgia that we were following. It looks like we do have a verdict. I am dropping the link if you want to head on over there to listen to the verdict live. All right, guys. Welcome, 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 everybody that's tuning
Okay,
in.
may we
It
have
looks
the jury,
like we
please?
do have a verdict. I seen that the judge was letting everybody know, in regards to their emotions and things, in regards to when the verdict is read. So, guys, let's tune on in.
All right, for the jury. Jurors, present and accounted for, Your Honor.
Thank you all. Please be seated. Will the foreperson please stand? Good afternoon, sir. My understanding is that the jury has reached a verdict.
Yes, the jury has reached a verdict.
Okay, and was that verdict unanimous?
Yes.
Okay, and has the verdict been filled in, signed, and dated by you as the foreperson?
Yes.
Okay, will you please hand it to the deputy, and then you may have a seat, sir. Will the defendant please rise? In the Superior Court of Fulton County, State of Georgia, the State of Georgia versus Christopher Wolfenbarger, case number 24 SC 004201. Count 1, we the jury find the defendant not guilty. This 22nd day of August, 2025. Will the state and defense counsel please come up and look at the verdict form and confirm that you have no objection to the form or legality of the verdict? Thank you. Counsel for the state, counsel for the defense, is there any reason that I cannot release the jury?
No, Your Honor. No, Your Honor.
Okay. Members of the jury, I'm going to take just a quick moment to thank you for your time and for your attention to this process. It was a long 2 weeks, but I appreciate that you were here each day ready to pay attention and to do your job. Thank you very much for deliberating, for being here, and for being willing to serve as a juror to your fellow citizens. I will also tell you, ladies and gentlemen, that in just a moment, I'm going to release you from further service as a juror in this case. I want to let you know that when you are excused, you are free to go. Enjoy your weekend. I want to let you know that you may be contacted by people about your decision in this case. You're not required to talk to anyone about your decision in this case. You can if you choose to. I often encourage people to, if you're comfortable talking to lawyers about your decision, to do so because it helps the lawyers understand what motivated you, what was persuasive to you, et cetera. It helps them understand and be better lawyers, right? So I always encourage you, if you're willing to talk to the lawyers that are involved in the case, it's always a helpful process. And so I encourage you to do so if you're comfortable. But if someone contacts you and you tell them you don't want to talk to them, you're not obligated to talk to them. And if someone bothers you or continues to try to talk to you after you've told them no, you need to let my office know, and we will make sure that that person does not continue to bother you, okay? Ladies and gentlemen, the last thing I will say is just that if you need any written proof of your service here as jurors, in this case, we're happy to provide you with any written documentation. And if you should have any issues with that, also let my office know and we'll do what we can to assist you. Thank you again for your service. You are excused. Have a good weekend.
All right.
Thank you all. Please be seated. Mr. Wolfenbarger, you have been found not guilty of the charges against you in this indictment, and the court therefore adjudges you not guilty of the offenses charged and orders that unless you are being held on some other charges, that you be released. Anything else that I need to take up from the defense?
Am I released right now?
I believe you have to be processed through the jail to actually be released to the street. There is paperwork that has to be done. Anything from the state? Okay. This matter is adjourned.
I know I'm muted. So it's on my anyway, let me get it on. I don't want anything. Wait a minute. Wow. Well, they deliberated for about almost close to 3 hours, I believe, guys. So there we have another one that we have taken it all the way to trial, right? We knew what this one was going to be about. We were screaming, not guilty, not guilty, not guilty from the start, right? Wow. That had to be a sigh of relief. I see Melissa's family hurry up and got out of that courtroom. You know what was interesting to me and what I would love, I love it. I wonder if they're going to do some type of press conference afterwards. I'm going to have to go in here and start searching to see if we could find any press conferences. Let me see if anybody speaking. You know, I almost thought he wanted to jump up. No harm, no foul. I thought that he might jump up. Just out of habit. I thought if you would like a certificate, you can email therapist. You want them to email you? Yeah, we give out, you get a certificate for completing the trial. We'll take it to trial. You will email therapist. You see, her email is in the thing. Put your name and say certificate, and she will get your digital certificate for your trial completion. Absolutely. This way you will not ever forget what trials you watched. Just create a digital folder. Wow. You don't think she better? I'm about to see. She about to be on there like, they got it wrong. Let me see. Oh, goodness. I don't know how soon they come out. Let me see. I don't see nothing just yet. They was running out of that. Okay, Cynthia. Yeah, I don't see nothing just yet, but I wouldn't doubt it if they got some things to say, because I'm pretty sure they disagree with this decision totally, right? And right, and I can understand, because probably in their hearts of hearts they believe that Chris did it. They do not believe the dad did it, but I think that it could have been a couple people. You know, it could have been Mr. Dixon. It could have been she was in the wrong place at the wrong time. It could have been a lot of things that could have happened. They just really didn't have any concrete evidence pointing to Chris. But yeah, they ran out of that courtroom. But you also got to think of who you dealing with in regards to these cases, because you think about it, they just didn't put the case together great from Georgia's standpoint, as far as the prosecution team, and it was just all bad. Yeah, nothing. You're right, therapist. Nothing came up. They wanted to act like it was something with the DNA, but we never heard any evidence in regards to any DNA. Yeah, they should be. You know, and I think that if I'm not mistaken, I seen that Fannie had put another, I think they're about to try to do another cold case. Now, I might be mistaken on it, but I think I did see it. Yeah, they had, and they wanted to try to act like because he was hiding, that was gonna convict him. Like, no, that's a shame that they saw right through that. Uh, okay, I'm just trying to make sure we don't see nothing. Wow. Well, so we got our first day with Donna in. We wrapped up our Christopher. That outcome, we kind of, I was surprised that it took him that long. I thought it was going to be really quick. But I was kind of surprised that it took them that long to reach the verdict. Maybe they went to lunch or something. Because I was thinking it was going to be more like that last trial that we watched. Which one? That was Nicholas, right? With Jim, where the verdict came back. What was it, like 45 minutes? No, an hour and 15 minutes. I thought they were going to come back fast like that verdict, if not faster. So we have that. I do know that on I did schedule a stream for Sunday for you guys that was watching the Ashley Elkins trial. They did have court today again for that preliminary hearing. They did provide, the state is offering some additional evidence. I don't know how much more evidence they would need for this trial, but it appears that they had another preliminary hearing today. It doesn't look like it was that long or anything. I think like an hour or so. So we'll cover that on Sunday. I'm not sure when the judge is going to decide to take this to court or not, but I think the live feed is about an hour and 36 minutes. So if y'all want, we can do that on Sunday. And that way we can look at that case. So that'll be a short Sunday. And then Monday we will be back into Donna, right? We'll see what Donna has in store for us. Wow. Yeah, I'm just looking at this stuff that they have in here on this case. That one should be very interesting. They got this parole hearing for Lau Menendez. Am I seeing this? Eric Menendez denied bail. I guess they doing his parole hearing now. Y'all know about that one? Yeah, it looks like they having the other ones bail hearing right now, or is this in all fairness, showing these things, and I be thinking they be live and they be old as dirt. Mm. Mm. Oh, his was denied. Yeah, okay, film. So they are bringing up, I'm looking back at the thing. Okay. Yeah, I thought I seen where Fannie was like making an announcement like they about to be the cold case people. Like, well, why did y'all cases have to get that cold? That was my first thing. Like, well, why are y'all cases always getting so cold? Yes, Lynn, it was definitely a mess from the start. That's what I can say. So let me ask y'all. Well, this is what I'll do. Let me ask y'all, and because I don't know how everybody's looking today, because we got done kind of early. At least it looked like it's early to me, right? Do y'all want me to? Do y'all want to do the Ashley? It looked like it's an hour and 36 minutes for that trial. Do y'all want to go ahead and cover that today and just take off Sunday, or how do y'all want to do it? Our Daryl Brooks Jr. I wonder if he's gonna be in. I wonder if he's gonna be in the courtroom today. That should be interesting to see. No. As the girl, this is Ashley Elkins. This is a girl that was she's been missing since January the 2nd, and they think that her boyfriend unalived her and dismembered her. They don't have a body just yet, but they are doing a preliminary hearing. And it's day 4 of this preliminary hearing where they're trying to determine if they have enough, if the state has enough evidence in order to take it to trial. So that's that one. And so it looks like that stream, it'll probably be like an hour and a half. Yeah. Yeah, and SD, if you didn't see on the channel, we do have the first 3 days on there. So if you want to watch to kind of like catch up on anything, a lot of pictures. That's what I can tell you. A lot of pictures, a lot of videos. So if you anything like any of us, most of us that's in here, we definitely like when we get a lot of pictures and a lot of videos. Right? I am a visual person. So if I can see it, I can believe it. Okay, so let me go get the link. We'll close down this room so this be separate. And I will open up the studio for our DeAndre Booker, aka Daryl Brooks Jr. That's what I want to call him, Daryl Brooks Jr. Yeah, it looks like it's about an hour and 45 minutes, so it doesn't seem like it's that long. So that way we'll have Sunday off unless I find something that's great over the weekend and have to bug y'all. You know, if I find something great over the weekend, I'm gonna have to come back and be like, no, 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 we got to get together. We got to get together. Okay, so here's the link for the Ashley Jenkins room. Definitely put your seatbelts on, buckle up. If you're interested in seeing this case, we're on the 4th day of our preliminary hearing. You're more than welcome to come over and visit us here. Once again, we have, I guess justice was served in Christopher's case, considering that the prosecution team didn't provide great evidence. They didn't put on a good case. And according to the law, you have to be proven guilty beyond a reasonable doubt. And unfortunately, the prosecution team did not have it. Right? So, we have a case where he was found not guilty. Unfortunately, whoever is responsible for Melissa's unaliving maybe possibly still out there, or maybe it was her dad, maybe it was Mr. Dixon, maybe it could have been Christopher. I don't know. I don't know if I'm thoroughly convinced that he didn't do it. But what I would let you know is that, unfortunately, the prosecution just didn't present a good case. Y'all so funny. Okay, so here is the I'm dropping the link. If anybody wants to go over and watch that one, we have wrapped up another case. Please make sure that you, if you want a certificate, email therapist you know, and she'll get that digital certificate of completion of their trial prepared and ready for you. If you're not coming over to watch the case, we will definitely see each other on Monday, right? We'll be back in the courtroom with our girl, D. Addison, Mama Gotti, and the gangster reunion, right? Everyone have a very awesome weekend. If you're not coming over, and remember, you're always in the right place, right? Where there's no filters, no fluff, just facts, so you can be the judge. Guys, have a wonderful weekend. If you're not coming over to see the Ashley Elkins case, if you are, I will see you over there. Have a good one.